Yes.
I pray for allowing me to submit an adjournment slip for 17th. I will be out of session. It's a hearing stage at 2 p.m. The order was passed on last location on the prayer of respondents. I was not there. It may come up with the following week.
Okay, you ask some junior to mention on 17th,
May I please your lordship?
but put your name out there.
May I please your lordship, with the consent of other side, I beg to mention item number 12.
Item number
Item number 12. Senior is out of station for his medical treatment.
12, it has come up for orders. Why?
Senior is out of station.
So what? Don't come up with this stuff.
Please, Your Lordship. Lordship, my prayer is for this CRP IO. My Lordship, matter will be.
What is the matter about?
Matter is basically petitioner filed a petition under order 11 rule 14. That additional production of additional document, and which has been rejected.
Okay, 26th March. 6.
For drill, item 1.
Lordship, so far this bill is concerned, we filed a joint application. Is it withdrawal on Lordship on compromise? But
Where is it?
I was filed.
It
It is not tagged, Lordship. It is filed on 19/2/2025.
So we have to adjourn it if that I is not here.
Lordship.
Number?
I number, it is not number, filing number is there, Lordship. It is 19/2140.
It has been submitted by Mr. Bhuya, the Learned Counsel, that an interlocutory application has been filed seeking a joint compromise decree, seeking a compromise decree. So taking into account the above, list this matter again on when?
Tuesday, Lord.
Next Tuesday.
Lordship, next Tuesday.
No. We'll have it on 19th. 19th.
Top of the list, item 2.
My Lord.
Your challenge, what order?
Yes, Lordship. So, in order it is 98, my lord.
Oh, I remember.
That matter, contingent clause. The agreement is page 20. The key aspect of the matter, my lord.
Now what has happened? There is no separation.
No separate. Clause 1 says, my lord, that the purchaser has agreed, provided there is a condition. The 40% is separate. And clause 2 and 5 says that there was a time limit from first 2 months, thereafter it may be extended to 2 months. And if not separated, then the purchaser has a liberty to withdraw his money.
No. The vendors have agreed to get it separated and then convey the same to the vendee. Isn't it a covenant by the vendor that they would also get this separation done?
Yes.
And wouldn't that amount to his specific performance is not only limited to execution of this agreement and the specific performance of the agreement, which also includes that you take steps for the purpose of separation.
Separate.
Because, just for example, let us think, you don't take these steps for 3 years. And you take a claim that I have not been able to get it separated, I have not done it. And he does not take any steps for 3 years. Then wouldn't it be barred by limitation? Because if I remember the judgment of Fateh Chand's judgment, wherein it also mentions a very important thing. It is a case under Order 7 Rule 11 where that proceedings was taken as regards it was barred under Article 54. 54, no?
54.
54.
If the date is fixed, then.
No, not the date, not the question. Here there was a thing that there was a requirement of taking a permission also.
Yeah.
Now he takes the claim that I have not taken the permission. So he doesn't have a right. And as such, he has not done anything to that. The plaintiff comes out there, he has not taken the permission. And as such, my cause of action did not arise. The Supreme Court says that it is not only the deed of sale which is to be executed. His specific performance was also for the purpose of the permission also. So if that permission was there, so wouldn't he have, therefore, a right for specific performance insofar as getting a specific performance against you, that you also take steps if you have not taken steps for the purpose of division?
Correct.
It is a different thing that these 60% or the 40% of these people are not parties. If they are not parties, that might also be a fatal. That is another aspect to the matter. But then also he has a right of specific performance as regards this line.
My contention is that first of all, that the agreement is a conditional agreement on a contingent effect of the future event, that if it is not separated, then he will take back the money. If it is separated and not performed, then he has a right to, for a specific performance through a process of law. That is
Let
a-
us see where
yes,
where it
Yes,
says-
yes. My lord, kindly have a look first, clause 1,
Clause 1 I have read, clause 2.
clause 2, my lord. Clause 2 is that the total value of the such and such, fixed as such and such, after partitioning the share within 2 months. So therefore, I'm just taking note of this time limit fixed. The vendor is also agreed to purchase the same at the roof price, provided the contracted share is separated and conveyed thereafter free from all companies. So there is a condition that I agreed to purchase, provided it is separated. Now,
But then also, there is also an agreement to the effect that you are going to take steps for the purpose of partition.
my lord, that is there.
That is there.
Yes. Now, lordship is important is clause 5. It is also agreed by and between the parties that in case the vendor's first party is not able to get the partition done within the time stipulated, then the period of this agreement shall be extended by them till another 2 months. Or as may be mutually decided by parties. However, in case of this part is important. Inordinate delay or non-extension of period. Here in the case non-extension of the period. By the first party as aforesaid, the second party shall have the option to get back its advance money paid to the first party by coming out from the contract, or to seek extension as the second party shall decide. Now, no extension has been asked for by him. And the first party shall be bound by the same. My lord, if the vendee seek for an extension, then I am bound by the same. Otherwise, he has to get back his money. This is a clear terms of the contract. Now, it was by that way or that way that extension was not asked for. And thus, this effects remains that no separation of the share is. Even in default, perhaps sake. But it is the option of it is the liberty of the vendee to take back his money. Now, 6 is also important, my lord. when his right accrued for specific performance.
So did you return back the money?
I'm coming to that. Lordship, kindly have a look at clause 6. That it is further agreed that upon if after a separation, this word starts with if after separation of the vendor's 60% share, the vendor fails to execute and register sale deed on obtaining NOC, the vendee shall have a liberty right to get the sale deed. Then only his right has came in action for specific purpose. This is one of the matter. The another aspect of the matter, which is also my respectful submission before this only 40 years, that the 40% separation is unseparated land is admitted. Now 40% share of the person, they are the third party. They are not the party to the court. Now they have filed a suit or also seek for a partition, asking me to partition the land,
Who has filed?
the painting, the vending. Now they are not the party to the agreement. Now in a case of the Supreme Court 2022 law, that's it, that section 12 came into place. If third party is not a party to the agreement, in that case, there is a case that the vendor is required to execute a sale deed, an arrangement with his brother's wife to access to the land to reach the suit land, the portion of the land of his brother's wife in between the suit land. So thus to reach to the suit land, he has agreed to have a negotiation with his brother's wife. The Supreme Court says that the brother's wife is not a party to the agreement. So you cannot enforce the specific performance to a father. So my respectful submission is that this judgment also covered our case also.
So your submission is to the effect that in the, let us apply that law, what you are submitting. Though they may have a right on the basis of a covenant that you are willing to take steps for the purpose of partition.
Right.
But he cannot seek for specific performance of that clause of the agreement in absence of the third party.
Yes, 40% share of that, those
So
persons.
the third party cannot be a part of the specific performance.
Yes, they are not a party to the agreement. So this is the, and therefore, if we read the agreement as a whole, that the right accrued for specific performance only happens in a future event if the partition has not been affected. If the partition has been affected and thereafter I fail to execute the same. Only in such
Or in other words,
Right.
if they can't go for specific performance of that particular sentence in clause 1, that provident in clause 1, that you are going to take steps for partition, they cannot go for specific performance of the agreement.
my lord. So therefore, the word provided is there. The entire agreement is referring the word provided. The specific performance provided. So therefore, this is the contingent. So therefore, section 32 and 35 of the Contract Act cancel. And in similar case of Telangana High Court, I am searching, but I have not find any other, our High Court or other High Court. Telangana is recent judgment I find. A similar case. There is also an agreement that the vendor will take a step for access to reach the suit land, which has not happened.
Now and what do you say about the delay?
Then the third submission, my God, the
We are still on the first.
oh no, I'm first and second I'm submitting, There is a section 12 of
The first submission was that the contract is contingent,
continue.
meaning thereby, yes, there is an agreement, there is a clause in the agreement that you are to take steps for partition.
My
he cannot seek specific performance of that portion of it.
Yeah.
Because of the fact that there is an involvement of third party who is not a party to the agreement.
And that also, my lord, in
And
addition to
such-
that, that also a specific time limit has been fixed. 2 months, thereafter 2 months. And the most importantly, he has a right to seek extension of the time, which he did not. So he failed in performing his duties also. So these 4 months has expired.
But what
No.
about you keeping the money?
I will, then I'm coming to, I'm coming to that. After 5 years of period, when he has not seek for any extension of time, after 5 years, it is, agreement is 22. Now, after 5 years in 23, I wrote a letter to him and returned back the money. 15 lakhs. That's
When?
the
When
Look.
did you return?
20,
When did you return?
in 23, after the expiry of the period of the agreement, there is a limit, 3 years, 4 months, then 3 years. When we reached at 5 years, then I wrote a letter to him, that look, the agreement has been expired, 3 years, you have not taken any steps, and I returned the money. Then he woke up, and then he replied to my letter. Then he said, he again returned my check and said, no, you are in default. So thereafter he filed that suit. Now my third limb of submission, my lord, that Lordship is well aware that here in the specific performance case, Article 54 is applicable. Now 54 is 2 parts. If date is fixed, then it's commenced from the date. If no date is fixed, then from the date of the refusal. Here in the agreement, the date is fixed. The contract period is fixed. That 2 months, then 2 months, then thereafter, after separation, I have to apply. So
But can I go into that question now in an injunction?
no. I'm just submitting, my lord, to satisfy this honorable court on whether there is a prima facie case or not. Whether the agreement is enforceability.
So your prima facie case will be on the first argument itself.
Yes. So it's
That
a
without,
contingent.
if he can't seek for a specific performance of the first,
Yes.
in absence of the third, the third party, then he cannot go for specific performance of this agreement.
Absolutely.
That's the
So I
limit.
place 2 judgment, my lord, for consideration. My lord has, I need not to submit, but for my satisfaction, I submit 2 judgment of the honors. One is Telangana High Court and one is Supreme Court. Telangana High Court,
Let
there
me
are
come to
10
the
onwards.
Supreme Court.
Ten is the condition of the agreement.
It's specific. This is a company or what? The property.
It's a private property.
Now, what is he asking in the suit? He's asking for what?
Asking for all specific performance of contract, direct me to get the land partition. Because unless partition, specific performance cannot be enforced.
So without a partition, they cannot.
No, absolutely not. It's unpartitioned land. There's no perfect partition.
And there is a specific agreement that only after partition this can happen.
Yes.
So
So
the
the-
court cannot specifically perform, give you the right or him the right to get a sale deed in respect to the 60%.
Yes.
Without a partition.
Without it.
This would
So
be interfered
therefore, the
with.
participation of the persons having 40% share is required also in the agreement as well as in the suit also. They made a pro forma defendants in the suit, but in the agreement they having no room to play. And there was no evidence that there was a consent or approval on the part of those persons having a 40%.
Now, what is the injunction given?
Injunction is not to transfer the land.
You cannot transfer also without partition.
Hello?
Can you partition, transfer without partition?
No, I can.
So why are you aggrieved?
Because the agreement has no enforceable number one at all.
That is
And number
that
two-
will be seen in the suit. Now, if you keep on waiting, you don't do that. What happens once the injunction is vacated, then you get it partitioned. What right he will get?
The 20 has no locus to find.
Normally, what happens? A person does an agreement with A does an agreement with B, where B doesn't have the title. But tomorrow the B gets the title. Then A has the right to get specific performance in respect to that title.
I understand the query of this Honorable Court, but my contention in my lord, that it is that so far the time is concerned, has been already been lapsed. So therefore, there is no enforceability of contract.
But you returned it only in 2021.
20, what I
23.
returned on
23.
23, my lord.
So why didn't you?
I'm ready to pay whatever the compensation of the interest, whatever the matter is, that I agreed to.
But
So
you returned only in 2023,
after the 3 years,
meaning thereby his entitlement was there, that you should have said to him then. So he approached this court within 2 years. Whether he is entitled to the decree is a different thing. But the question is whether this court now say that his suit is not maintainable.
absolutely not. My lord. Absolutely. We are that, therefore, we have filed an application under Order 711 also in the Pattai Court for rejection of the pay
On the ground,
on the ground that it's not enforceable about the agreement. And number 2 is the Bharata Injunction. Section 2, the Article 2.
I won't be sitting when it comes to me.
Lordship. Lordship. So therefore, Lordship there is no prima facie case here.
No, only, yes, there is a question to that effect, but what happens? Tomorrow you get it passed.
There is
The
so many
moment the
probabilities
injunction
of
The moment the
either of the, we can purchase the 40% share also, or the 40% share can, being the co-owner having a right of the first preference, also get the share transferred of my 60% to that. So there is, this section 22 Lordship is whatever the transfer of property act. So therefore, my right can be purchased by the other party can, all are the co-owners. So therefore, then either partition also may not be happened on, both the parties can exchange their.
But what do you say about the section 44 of the transfer?
That is there, my lord. But so far the co-owner is concerned, section 22 is there, Lordship is also there, having a first preferential right. So we may purchase their 40%, we may sell the 60% to them. So that option is available in between the co-owner.
That is available, but that
But
available.
if the injunction is
That is
yet
always
between the
subject to the
clause
agreement.
in then that though all those transaction also not to be. That is the whole trouble. We may not transfer it to a third party, but we may having a right to transfer in between the co-owners. So the injunction order may put a clock on this. And absolutely, prima facie is part of limitation because the agreement having a time frame agreement. It is not that there is no time. So when there is a time frame, my lord may appreciate that it has to be 3 years. It is not a question of mixed law and fact to be decided. The question of the limitation. The prima facie, it is the 2 months, thereafter 2 months, he has not seek any extension, so he has lost his right for seeking extension. And his right has only accrued if partition is done. If partition is not done, then he cannot seek an enforcement of the contract.
What a performer.
Proper 40%.
They are there.
Now, Lordship, kindly have a look for a moment. Page 39, the prayer portion, prayer C. Now, the 40%, they are not the party to the agreement.
And has the performer defendants filed a written statement?
No. They have not. Now, another aspect of the matter, my lord, is may helpful for deciding on this. That in the entire claim, There is no a single sentence or whisper that they are ready and willing to perform their work.
It required now. It required now after the amendment.
But
Article 16C,
yes, that's the amendment.
now there's only two.
Yes.
Reading
Now,
is
now there is another aspect to that effect, why I'm saying so, my lord, that during this period, in 2018, we agreed at 1 crore 20 lakhs. They only paid 15 lakhs. Thereafter, they have neither tendered nor they have doing anything. Now, after 5 years, my lord, after 5 years paying 15 lakhs only in 2018, thereafter, during these 5 years, they did not tender anything. Neither they expressed no communication, nothing has been happened. Now they're seeking the decree, specific
But they
performance.
categorically mentioned in paragraph 5 the claim that they have been taking steps in that regard.
There's nothing on the record.
Although for them, Corona started in the year from 2019. Paragraph 5 of the claim, page 34.
Yes. Then, now, they only replied after receiving our notice and receiving the amount in question of 15 lakhs. After the 4 months, it was their duty.
Mr. The only thing which I am finding it difficult to verify that one of your submissions in the impugn order, as reflected in the impugn order, that the value at that time was 1.2 lakh, 2 crores. It's 2 crores, and he had paid 15 lakhs. Now the price has gone up.
No, that's not the matter, my lord. It is also a contingent submission. It is also that's the aspect, my lord. It's not a legal parameter because but the question is the
So,
question.
the doctor, you have to be careful when you are making these submissions and being recorded. Will have a harmful effect.
No, we
Which
have
means that
no,
you
no,
have no
we have
intention-
filed our written submission, my lord. And in that written submission, in the record, we have not said such a point. It's the 1 crore. We need some more. It is not our stand. Our stand is very, very
It has been recorded.
yes, yes. I understand.
Well,
In the written objection, we have not pleaded such a fact. And also my notes of argument. Ordered by the court is final. And that's there. That's there. Why not they came forward after 4 months of 2018, my lord. In 2018 itself, they must come forward and seek extension of the time.
then why didn't you write in the year 2019 itself? That look here, everything is over. I'm not going to do that.
Therefore, I'm keeping their 15 lakhs. I am required to pay the interest. I will do that.
It's a different thing, but the question of interest or compensation is not the value of the thing in view of section 10.
Lordship, our lordship also kindly appreciate that the 3 years limitation period is there of the specific performance from the date of the performance, my lord, if the date is fixed. So therefore, we may reasonably explain that part also, subject to correction to this. The 3 years I have to wait. There's no prevention, that there is no harm on my part that to write up to 2018 itself. I'm not doing that. But so for the specific performance of the contract is concerned, since that is date is fixed,
But why did you have retained the money even after 3 years?
Therefore, I'm liable for the compensation on that
No,
part.
it's not
my
a
lord.
question of compensation. You have, that means there's something to believe what has been stated in paragraph 5. Only worry is, Mr. Doctor, the Becky. If it is the case, because that submission which is there, this court is human, have to take note of that. Is it the intention of you to get this thing, injunction vacated, and thereupon you do it? You transfer it to the 60% to him and therefore making the entire thing nullified. That is why the court had passed the order that tomorrow, in the case that you give him the right under 22 and say that, okay, you take over this land. I am supposed to sell him at 1.2. I will sell you at 1.4.
Lordship, if that being so, it's a very correct, in the mind of the court.
The question is, can this court, in exercise of its appellate limited jurisdiction, interfere now on the basis of a reasoned order? Yes, your point is very appealing as regards in a suit for specific performance, there can be nobody else in a suit. Their performer defendants have no role out there. It's okay. That is in a suit, it is so. And the court cannot grant a specific performance for partition. And if no partition is given, they cannot
The
be a specific.
agreement cannot be enforced.
But that is appreciable. But are you saying that tomorrow, if the performer defendants come up out there and file their written statement and say that, okay, we are agreeable, then what happens?
And that also is possibilities
And the court does not strike out performer 4 and 5, then what happens? And the performer defendants don't come out there and even say anything, what happens? The court can possibly.
the proper came and saying that that we are not agree with the partition now, then the agreement cannot be enforced.
So
Cannot be enforced.
you have to get hold of that. That is why I asked him. Did the performer say that?
The performer is only a party. Huh? Injunction order, they were not the party.
Obviously, the injunction is not against them.
Against them. So therefore,
But the question is, have they filed a written statement saying that we are not going for any partition? The moment it is there, then it strikes on the court
my lord,
jurisdiction to issue because the court cannot direct.
may I request my lord of one thing? Keep the matter pending, my lord. Let the written statement be waited. If they take a stand, my lord, no, we are going to separate. My lord. Then there may be a case of prima facie case. There may be. I am not saying.
No, you see, take the eventuality, they say we agree.
My lord,
Take the eventuality, they say that we have no objection in separating, or they don't say anything.
or they may say
Or
that
it
we
may
have a
go
differential
or
right.
it
my
may-
lord.
Or
We have,
they appear and don't don't file the written statement, or even they say they don't say anything, it goes ex parte.
yes.
Then the court may pass because they have been there in the parties.
So my humble request, my lord, let the matter be kept pending. If this is a very important fellow from some court, but it's a very important aspect also. I also fully agree with you. My request, my lord, to keep the matter pending and being a part of it, substantially hard to resolve the RTO officials. And let the
Mr.
happening.
Mishra will oppose making it part of, because I have not heard him till now.
But that is up to the honorable court, my lord.
I've only heard you. Have I asked Mr. Mishra to say a word? No.
But that's my request. I can only make a request, my lord.
I won't be here for 14 days now.
Yeah, no, I don't know what the next date. It will take 1 month time minimum. My lord. Not no, because nothing to be happening, my lord, because there is an injunction order against us. So let it be continued because there is no stay.
Yes, Mr. Mishra.
My lord, we came to know that there is a suit fight between the third party and them regarding separation. Their title was already decided and petition was already done pursuant to a compromise decree passed by the Calcutta High Court. And it is there in the recital. In the recital of the judgment, my lord, will kindly see.
You have filed a reply?
No, this is, my lord, I'm referring to the agreement.
By the agreement?
Agreement to sell, page 20. The relevant recital, your lordship will find at 21. 21. Whereas Schedule 1 property was part of a state belonging to so and so, Stilcher, and as per compromise decree so and so by the Calcutta High Court, Schedule 1 property was distributed, allotted into 3 lots. Lot A was one Subhas Bhuiya exclusively, Lot B Syamal Bhuiya exclusively, and Lot C, which is described in Schedule A below, to the proposed vendor, and Lavanya Bhuiya and Lakshmi Bhuiya, they are the opposite party, third party, jointly having their respective share declared.
And with
Lavanya Bhuiya
50%,
50%,
Pranab Bhuiya, and accordingly named the proposed vendor, Lavanya Bhuiya and Lakshmi Bhuiya. Who did this agreement? Deep Saha and all these things are,
now all melodies except the Lavanya Bhuiya and Lakshmi Bhuiya, they all other are the vendors with whom I have the agreement.
okay.
And it total comes out to 60%. Mutation is already done.
Mutation done.
Mutation that is written here only, your lordship will see. And Lakshmi Naran Bhuiya have last time, have duly been mutated in the land of records.
Where is the document?
Means at this stage I can't.
Produce this.
Their names already been all, pro forma defendants and the defendants, their names
No,
mutated.
understood, but produce this particular document
That
on the
will-
basis of this you have mentioned out there, because this must have been your representation at the time of entering into the agreement. Produce this document. This, first the Calcutta High Court's order
Yes, yes.
as well as
Thereafter the mutation order.
and the mutation.
That will go.
Produce it.
By an additional. My lord, let me just show few more things.
Yes.
Should we like to have some further clarification on it? The next paragraph, in the next recital.
Mr. Mishra, further going out there, you bound me to make it parted.
No, I'll not say anything. I'm keeping, actually, I never intended to even rise and say unless you lordship ask me.
No,
something.
it's okay. I don't think, I will keep it parted, I won't.
My request only, my lord.
No. FAO people, if I make it parted, people will laugh. I only make parted when I see the government is not doing some action. Otherwise, no. Otherwise, this would have
I
been
leave it to this
disposed.
honorable court, my lord.
I dispose it of, next day, let us have it, but I won't be there. But when can you file it? If I am here till 28th, I'm here. Can you file it before? that?
Yes, yes. We can file it. 28.
Or
We can
Mr.
file it on the.
Mr. B. Dotto, the
But
learned senior counsel, assisted by so and so, and Mr. D. K. Mishra, the learned counsel appearing on behalf of the respondent. Senior counsel assisted by Ms. So and so appearing on behalf of the respondents. The instant appeal is directed against the order dated 9/1/2025. Passed in case number 283/2024, arising out of title suit number 177/2024. Whereby the learned trial court, that is the court of the civil judge senior division number 1, Kachar at Silchar, had passed an order. Had passed the order directing, granting a temporary injunction, thereby restraining the appellant herein. Appellant's herein. their men agents, etc., from alienating the title or transferring the possession of the Schedule A property with 60% of the principal or share of the principal defendants, public the appellants herein, to any third party, or from changing the nature and feature of the same till the disposal of the same suit. Mr. The learned senior counsel had submitted that the plaintiff did not have that, taking into account the agreement dated 1st of November 2018, it will be seen that the agreement is a contingent contract. And being a contingent contract, it cannot be specifically enforced till the happening of the contingent. Referring to clause 1 and 2 of the agreement dated 1st of November 2018, the learned senior counsel for appellants submitted that the appellants were required to get the 60% share of the Schedule A land separated from separated, and then only it can be conveyed to the respondent herein, who is the plaintiff. The learned senior counsel submitted that this very stipulation contained in the agreement, specific agreement, cannot be specifically enforced, taking into account that those persons, taking into account that the other co-sharers of the land were not parties to the agreement. He further submitted that unless and submitted that as without there being a partition, which the trial court cannot order, as the other co-sharers are not parties to the agreement, the plaintiff oblique the respondent herein did not have a prima facie case. He further submitted that the said agreement had expired due to a flux of time, and as such, the question of specific performance did not arise. Per contra, Mr. D.K. Mishra, the learned senior counsel appearing on behalf of the respondent, drew the attention of this court to the agreement dated 1st of November 2018, wherein it specifically wherein it has been specifically mentioned that there is already a compromise decree dated 2/2015, which was passed by the Calcutta High Court in EO suit number 04/2014, whereby the shares in respect to the appellants herein have been clearly identified, and the remaining Huh?
Appellants and
appellants herein have been clearly identified with that of the shares of the pro forma defendants. He further submitted that pursuant thereto there has been already a mutation done, and it is on in that pretext, in that it is on that aspect. The agreement was it is on that understanding the agreement was entered into. He therefore submits that the clause 1 of the agreement, clause 1 of the agreement is only regarding certain formalities to be completed, inasmuch as the partition have already been decreed by the Calcutta High Court. The learned senior counsel further submitted that it is an admitted fact that an amount of rupees 15 lakhs was paid. The respondents herein, the appellants herein, never all along informed the respondent that they would go ahead with the said agreement. And this very aspect of the matter can be seen from paragraph number 5 of the plaint. It is only when the appellants have returned the amount of rupees 15 lakhs by issuance of a communication, the respondent, who is the plaintiff, had noticed that there was that the appellants were not, the defendants were not interested to proceed with the agreement dated 1st of November 2018. He therefore submits that the instant suit will come within the second part of Article 54 of the first schedule, and as such, there is no bar to the limitation. Taking into account that the agreement dated this court upon hearing the counsels and taking into account that the deed of agreement for sale, which is the subject matter of the litigation, categorically mentions about a compromise decree and also about mutation of the land records. This court fixes this matter again on 26th of March.
21st, madam.
21st, so early. On
Yes, sir.
21st of March
I have
2024.
another matter, madam.
Fantastic.
Kindly accommodate.
On 21st of March 2025. Full stop. In the meantime, the appellants as the fact pertaining to the compromise decree as well as the mutation of land records have been put in the agreement at the behest of the appellants, they are directed to bring on record the said compromise decree as well as the mutation order by filing an additional affidavit.
Right. The lordship is fixing on 21st of this month.
With
26th or 27. Grateful, madam.
This is the matter for further consideration.
For admission item 327.
Kita pun boleh dulu. Mr. Das, you got back the book? You got back the book? Whatever mean.
Yes, I'll hand over.
No. He was very worried yesterday. I've lost the book.
Yes.
Yes, government, what has happened?
But on the other day, but I referred to the instruction given by the government and the records. But they said that as per suggestion of the finance department, they have sought for some information from the registry of the Sonabal Code. And my information is that the registry has not given the information till date. They have not received.
And where's the finance? Finance has caused the problem. Personnel has already given.
There-
Personnel is okay with it.
Yes.
Only remains with the finance.
Finances, there is some query. And as per the suggestion of the finance, the judicial department has written to the register general of the Sonabal Code, and some information has been sought. From the reply from the registry is awaited. I have talked to the officers of the judicial department. They are awaiting.
Where's the finance? Finance. And why? I mentioned about this thing in my order last time,
Yes.
Mr. Das.
Lot.
Had written a letter dated 24/2/2025 to the Registrar General. Did you take the information?
5 minutes then. I'm getting there.
I'll do one thing. I'll take it up at 2.
Lot.
Get your instructions on this. And Mr. He is also not there.
Item 8.
Please. My lord. And senior counsel is on the way.
What is the matter, Mr. Bokasta?
Regarding promotion to the post of UDL also. I was initially appointed as copyist. Thereafter, there is a notification from High Court that copyist, computer assistant, all are eligible for promotion to the post of UDL. Accordingly, I am now senior most. The rule says seniority come merit. Now they have first they have taken a resolution that a written examination will be held. I have participated in the written examination, and subsequently they have stated that there is a cut-off mark of 60%. And according to
Out
their
of?
cut-off mark of 60%,
Out of?
out of 80.
But where is the government? Who appears?
Now, yes, Guwahati High Court.
Where's the High Court? Nobody. I think
No,
we
sir,
asked
the
the
judgment
Registrar
is clear,
General to
Lordship,
be
even-
present. High Court is not represented.
Like that Ms. Sharma was appearing in last time.
Bhavan is appearing on behalf of the High Court. So we asked the Registrar General. Because first of all, if it is seniority come merit,
Yes.
how can you have such high standards?
Yes, it cannot be. That is my case, Lordship.
Huh?
Now 76
What
judgment
is
says
wrong with this?
76, 98,
Yes, who
2021.
is appearing for the High Court? You are appearing for the High Court. Where is she?
Yes, Sharma,
Where is she?
on the way.
Speak. Yes, Mr. Nath, Mr. Das, tell me. You are to have a minimum cut. Minimum. When it is seniority come merit, you cannot convert it to having it like merit come seniority. You have to have a minimum benchmark. Can you have out of 80, 60?
60%.
60% is minimum.
Not 50%. That is 30%. How can you have 50% also?
What has been done here?
This is absolutely encourages. How is it possible? You cannot have 50% also. You have to have the minimum standard that this is required for him to be in the high qualification. What is your basis to come to that opinion? That you make it 60 out of 80?
60 has been made minimum.
Huh? Out of 80?
No, 60%, that is 48 marks.
Out of 80?
Yes.
Then?
60%.
60%, how can you have it? Isn't it more like a year? Seniority.
It's a debatable issue.
We
What will be the
we
minimum?
will conclude the debate today itself, now. This type cannot happen. Okay, that's why. High Court is not represented. Let me pass the order.
Converting to merit.
Where is it mentioned that 60%? Let us pass the
Percent.
order. This can't happen like this.
The resolution. Page 38. Page 40, Lordship, specifically.
One post of UDA has fallen vacant consequent upon superannuation of Jyotsna Swans. As per Swans, in view of the Iman, the Honorable High Court has post of Iman in the summary shall be treated as Swans. As the aforesaid two vacant post of UDA are of the promotion mass. Swans who has rendered not less than 5 years in the is found that 20 employees will be eligible to participate in the selection process for giving up one people post. Is it 1:20? Is the zone of consideration 1:20?
No, it was not that, but all the who has attended 5 years of service, all have been considered. As per the rule, 5 years must be completed.
Written marks, test of 50 marks. Vibhav said 15 marks. ACR 15 marks. Outstanding, for outstanding remarks, 5. Outstanding points. Board have decided that the candidates shall be required to obtain 60% in the aggregate in order to be eligible for promotion on the basis. How can you have 60%?
Now, that was not communicated also already.
We set aside this.
By filing affidavit, lordship, they have stated that I have secured more than 50%. I have secured more than 50%. By filing affidavit, they have stated.
Where?
Page. Lordship 65.
Huh?
Page 60. Lordship, sorry, page 49. Paragraph 10B. Last paragraph. Page 40.
Where is it?
Last
Page?
paragraph, page 49. Lordship.
That I say that there is no arbitration or alleged in prescribing here, the board considered the nature of the work and page 49.
Page 49.
And the petitioner secured 21 marks out of
Paragraph
15
10B.
written, 10 marks out of a month in 15, so and so in 10 marks out of 15. And therefore, to their combined secure 41 marks in total out of, which is just above 50% above the cutoff mark. And that is okay. You have got 50%. Are you the senior most?
I am the senior.
You need to interfere.
Just whatever I have seen page 40, this minimum mark is not only in the written. It has got components. Written exam-
Understood components, but how can you have such a high ranking marks? Why do you require 60%? What is your justification of having 60% when it is seniority come merit? Tell me.
One judgment my brother has placed, it says, I haven't gone through the entire, and just seen the relevant portion. During the course of the hearing of the appeal, the learned counsel for the respondent banks has placed before us the relevant documents relating to the impugned selection and promotion. On a perusal of the said document, we find that 50%, 50 marks out of the total 100 marks was prescribed as the minimum qualification for interview. So here it is 50 out of 100. Now, here it is 60%, or it's more than 50.
Which judgment?
This is 98 with 98 6720. PV Shivaya versus Atankani Babu.
Yes, I will also rely upon this judgment.
Paragraph 37. So.
No, question of interview, how does it come?
Yes.
But tell me, whatever this judgment may say, but my question is, how can it say, be said as regards an interview? What is interview? Again, assessment?
No,
Interview is
the-
assessment on merits.
no, that's it. No, here the assessment is, if we are conducting an interview only for the purpose of assessing the minimum merit, then it's fine. There is no problem.
No, in
Because
this
we can
case,
hold an
no,
interview.
in this case, one has to get 50% out of
That is also,
100,
I understand it. Out of 100, 50%.
50%.
Okay.
150% of having the minimum benchmark,
It says it's,
and then you can go for interview.
Also, paragraph 18 of this has been mentioned. No, paragraph 18. Sibaya. Yes.
We thus arrive at the conclusion that the criterion of seniority cum merit in the matter of promotion postulate that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have a priority and a comparative assessment of merit is not required to be made. For assessing the minimum necessary merit, can lay down the minimum standards that is required and also prescribe the mode of assessment of merit of the employee who is eligible for the demand. Such assessment can be made by assigning marks on the basis of appraisal of performance, on the basis of service records, interview, and prescribing the minimum marks which would entitle a person to be promoted.
Yes. This is not required. And
Why,
21.
why are you putting it 60%?
Yes, that question, it's fine. But so far as what system or what will be the process of assessing the minimum merit, whether it will be a written examination or interview, that has been, led to the, that free play has been given to the employer. That you
No,
assess
there's no
whatever
quarrel
method.
with that. But you cannot, in the name of minimum merit, make it a merit cum seniority.
One aspect I'll just like to place, Lordship will see here, it is not only on the basis, it's not a situation that an interview was conducted wherein, 80 marks has been prescribed and whoever gets 48, he'll get, he'll pass the minimum merit. Here, it's a component. There is a written test of 50 marks. Viva will say 15 marks, then ACR 15 marks. So ACR also marks were given. Whatever is performance in the last 5 years, that will be accounted. Then Viva will say 15 marks was given. This component may give a different picture, subject to what your lordship
This
sees.
type of,
And
this type of thing
40.
needs to be nipped at the bud.
he is 14 years junior to me also.
No?
It is also not equal.
Whether they-
Page 40.
You have referred to some, that resolution now, where is it?
Yes. Page, page 38.
Page 30.
38.
38, na?
38.
Written test, 50 marks.
And how much the components of written test?
Viva was 15 marks. ACR 15 marks.
Page 42, my lord, will have a look.
Yes, more than 30%, 21 months.
I'm just addressing.
So what is your basis to have it 60%? Tomorrow you may say, the employer has been given, so we have 90%. You may say, are you not altering the mandate of the rules? You have no business to alter. It is for the state government to do that. We need to interfere. There is no basis on which you have fixed it 60%. You may have 50%. The Supreme Court there was justification as to why the Supreme Court came to an opinion. There's no justification for here. It cannot be a basis justification why you have arrived at. See, the board has decided the candidate shall be required to have 60%. What is the basis?
Basis is all right, but the question is whether this 60% is minimum or not. Whether this 60% can be.
Now, in order to be eligible for promotion on the basis of seniority cum merit,
Yes.
then what is this? This can't happen like
Can
this.
it be construed to be a minimum? That interpretation may not.
Thing.
In Maheta, I
First
think.
of all, your government, you are not in a position to tackle with the government to get the rules done, making it merit cum seniority. So now, in the name of that, you have now converted this into disrespect. Tomorrow you may say that we require 90%, as we feel all these are required.
Not, what will be the minimum? That is, in none of the rule it has been provided. not only in High
No, no,
Court rule, in
tell
any
me,
other rule also.
tell me, under 235, the High Court has the power.
Yes,
Has the High Court given it that you have to have 60%?
no, not only High Court, my lord, in other rules also, wherein the seniority cum merit has been fixed as a criteria for promotion, therein also there is no mention that what will be the minimum merit.
So what?
So it is,
So there
it
has
is
to
for the
be a good
interpretation of-
justification. Why you want 60%? Because otherwise you are converting it. In the recent judgment which you showed it to me of Justice
Maheta, yes.
Padiwala,
yes,
in paragraph 31 of there, he duly recognizes to that respect that look here. Yes, minimum qualification is required to see a benchmark. What is the benchmark required to look into it? That okay, from here to here I can go. They can be taken into account. Why are you taking into account the ACR? ACR is not for the purpose of quantitative looking that this person has that qualification to the effect. We are having a written test.
Sir, I'll not take your lordships to that what the employer will see or not. But one aspect is even that judgment also it has been said that it should not, the line is very thin. It should not tilt to the merit.
This is the pure case of tilting towards the merit.
Exactly. So this,
We have
this
to
is what the
interpret it.
lordships could appreciate that whether it is tilting towards the merit or
It
not.
is.
If it's tilting, then it's not correct.
It is speaking directly. What is the basis you are having? Yes. What is your basis of having 60%?
This was to determine merit, page 40 of your lordship's brief.
Huh?
This was to determine merit, page 40 of your lordship's brief. That is what it says. my lord.
It is more like merit. Merit can't be like this. That's all of the government. Let the government give you all these things. But without that, have people who are not qualified, who cannot manage, then the government may face some difficulty. You can't convert it in this manner.
Seniority cum merit. A2 merit comes. Improve for one hour.
Even lordship, the Maheta judgment, page 98, paragraph 98, clause 4, says upon fulfilling the minimum qualifications, promotion must be based on interstate seniority.
In the 1976 judgment,
Lordship.
held that the policies pertaining to promotion can be broadly fall under two distinct promotion which are based on principle of merit cum seniority and promotions which are based on principle of seniority cum merit. Further held that when it comes to promotion based on seniority cum merit, a senior who has a minimum requisite merit
Yes.
shall be entitled to promotion even though there might be others who are more meritorious.
Paragraph 38, it is clear, lordship.
Of
This same judgment.
what does he say?
The principle of equality is applicable to employment at all stages and in all respects, namely initial recruitment, promotion, retirement, payment of pension and gratuity. With regard to promotion, the promotion, the normal principles of either merit cum seniority or seniority cum merit. Seniority cum merit means that even the minimum necessary merit requisite for efficiency of administration, the senior, though the less meritorious shall have priority.
Who is, anybody referring to 2006 12 SEC 574?
That's 76, 98, 2021, this one.
2006 12 SEC 574. Herein at paragraph 20, it says, there is no basis in the instant case for a stand that for assessing merit, a minimum number of marks has to be prescribed. The contention that the minimum marks were 45 out of 60 means an employee is to secure 75% of the marks. Such a high percentage cannot be a measure for prescribing minimum marks to assess merit. It obviously would be a case of shifting the focus to merit cum seniority principle. In paragraph 37 of the CBR, this court noted that the minimum marks prescribed for assessing merit do not depart from the seniority cum merit principle. But the factual position is different here. There is no mention that 45 marks of 60 relate to prescription of minimum marks for assessing. It has been noted that in a seniority cum greater emphasis on the seniority, though it is not the determinant.
The page number is 970. Even though 50% if is considered regarding Shivaya or this 2006 judgment, I have secured more than 50%.
No, I am not going to go into that aspect whether it should be 50% or not.
Yes.
There is no justification why 60% is the question. On this ground, one has to set aside, you have to justify why 60%. Whether it would then infringe upon the seniority come merit principle. You may have a justification for something, but you have to give a justification. Without that, nothing. Because you can't convert it. Yes, you may have 60. Like in that case, it was made 75%. By making it 75%, you have how many people got more than 60%? Did you find out?
My retirement is due in the next year, February. I don't have 1 year also.
You just find out I'm coming in 5 minutes. Huh? You must have had, after having those 60 people, 60%, there will be some persons who will be there. Or was it only one person? That also goes on the proportionality. It hits the principles of proportionality of fixing the minimum. It seems that you have done it by way of selection. You have got it by way of merit. We produce the minutes of the selection next Thursday.
So Thursday, I will be out of the-
Can be on Monday.
No, Monday.
27.
It will then go to 27th. You are delaying it. I wanted to do it early. You are delaying your proceedings for your plan.
So you provide for long loss.
They will always say they delay it.
I will also try to.
Because in the selection proceedings, there's nothing out there. It seems from this order that on the recommendation of the selection board. Was it done on the basis of without any selection proceedings to that effect? That means somebody must have got, how many people have got more than 60? How many candidates were there? Out of 20, how many persons got with 60%? This is a very important thing when you are having minimum
I have got a
principle of
copy
proportionality.
tabulation, Lordship. I have got a copy of tabulation. It's not part of the record.
You have got a copy of
Tabulation.
to me.
There are 3 persons, I think, secured more than 60%.
What is your name?
I am first, Lordship, Madhumita first. Real number 1. And serial number 5 has been promoted.
Tradition. Tabulation. 48.
Only 4% got, no, how many persons got
Uh,
60%?
3, 4, 5, 6, 7, 8, 9 lawsuit. More than 48.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11% out of
11,
20.
11, putting the response.
Then it seems reasonable.
And others are more than him.
Huh?
More than he secured 55.
No, 55 is above 5. You need the minimum 48. So kindly see here. Number 20 got 57. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 got. No, that seems to be reasonable.
No, I am there. He is 14 years junior. That used to be.
I'm not on junior, senior business. I'm concerned with merit. You see, only question on which this court can say as to whether the minimum qualifying marks was not proportional or rational. If it is unreasonable, this court can interfere. But out of 20 candidates, 12 have got more than 60%. 1, 2, 3, 4. 4 are absent, which means 16. 16 is out. So remaining only were 4. So can it be said to be unreasonable?
First lawsuit comparative assessment was not required of merit. Second, I have secured as per them more than 50%. And 60% is never a minimum loss. Cut-off mark of 60% for any examination. It is not minimum. It is always considering merit over seniority.
No. Here the merit is such, everybody is getting more than 60%. Are you going to say tomorrow that in this recently concluded CBSE exams, are you saying that the minimum out there for getting a good college out there should be 50%? No, it is at 90%. Everybody is getting 90%. So the benchmark is 90%.
It's there. Even if we follow Shivaya says 50% out of 150% is reasonable. Then this.
No, it will depend on the facts. Therefore, I asked them this, whether it was rational. When out of 20, 4 are absent, 12 has got 60, more than 60%. Then can it be said to be unreasonable?
That's why I submitted lawsuit. There is no proportional equality also. My appointment was in 1987. All are, he is 14 years junior. Whoever secured 60%, they are more junior than, more than over 44. Now, one person is appearing in examination fresh. He's fresh, just 5 years. It's a written examination. And another person is 20 years ago he passed. So whether their this merit will be equal.
Oh, that cannot be the basis.
But that is what lordship is. 76 judgment also says the proportional equality also has to be considered. Proportional equality. Competition was not equal.
We are concerned with the fixation of the minimum marks,
Yes.
isn't it? So if the question of fixation of the minimum marks is the question, so therefore the minimum marks would be like this. They have had 12% out of 20 who has 60% marks.
It may be lordship. Others, many of them secured 60%.
Yeah. For
But
that, you cannot say that it is not rational.
But that cannot justify lordship this putting cutoff mark of 60%. Because
I have
minimum,
understood there were only 4, 5. Then okay, 50% is less. less than 50%. Or even 7. But 12% have got it and 4 have not appeared.
Minimum only always lordship, minimum is cannot be 60%. Minimum and minimum for administration of justice, not merit. Minimum for administration of justice is to be considered. For administration of for efficiency of administration, not administration, efficiency of administration. So 30%, 40%, a person is working for long. She is about to retire after 1 year, and 14 years juniors have been promoted, and others those who have also
Mr.
secured
Professor,
admission.
that would be amounting to touching on the selection procedure. That you should not have so much of marks for written examination. I may not be in a position to write because our junior would be better off to write. But when you with open eyes participated,
Yes,
wherein Madanlal would not strike in.
that is there was no communication regarding 60% cutoff mark lordship. And that is what I have in my additional affidavit. I have submitted document showing that what has been communicated. Page 65 and 66 lordship. It was never communicated there will be 60% cutoff mark.
As per the resolution dated for filling up of the post, though promotion from the AI, total of AI will be eligible for participating in the selection process. The board has resolved to hold the AI test of 56 marks on so-and-so for Iman in the office room, and the Viva versa for 15 of all the candidates will be held in the chamber of Iman. So this is only 65. So this is only for the information.
50%. There will be a cutoff mark of 60%. It was never communicated.
Is it required?
So suddenly, lordship, that it would be according to their
No,
choice.
whether this was done prior to this thing, the decision,
Yes.
60%.
Yes,
60% was done when?
resolution they have taken earlier, but it was not communicated. I have
It is
specific
not
stand-
required. The resolution was of 17 to 2023.
70.
Thereupon,
This was communicated.
this notice was issued on 22 2023.
23.
So you work in the same establishment.
No, that cannot be lordship. These are secret recruitment, promotional recruitment, but these are secret thing, lordship. And my specific stand in paragraph 6 of my petition also in this additional.
When do you want the dismissal? Today or next week? That is your prerogative. Either.
Come on, 27th. 27th. I will try to convince again.
You produce the, yeah, because I can't take it on the basis of this. Yes. Mr. S. D. Pukasta, the legal counsel appearing on behalf of the petitioner, Ms. S. Sharma appears on behalf of the respondent. It's the respondent authority. You are appearing? The Chakravarti appears on behalf of the private respondent. 7. The challenge made to the appointment of the respondent number 7 as a upper division assistant is on the basis that the minimum qualifying marks, which was fixed at 60%, was not rational as well as reasonable. For the purpose of deciding the same, this court finds that the minutes of the selection proceedings, along with the connected records, be placed before this court on the next date. List on 27/3/2025. Yes, take this. Madam, you produce that record because on the basis of this, I cannot dismiss.
Item 9.
May it please your Lord.
Hmm.
My lord, the matter relates to a rule framed by the CJI, my lord. Sorry, Chief Justice. Honorable Chief Justice, which has not been approved by the state.
That's the 2013.
Lord, Lord, normally there are 2, 3 Supreme Court judgments, Lord, on interpretation of Article 229. The underlying principle is, my lord, normally whenever there is a rule framed by the CJ, and when it involves financial involvement, it requires state's approval, governor's approval. Governor's approval means, my lord, not in his discretion, on the aid and advice of the Council of Presidents. It is said, my lord, all the judgments, that normally it is given. Now, if it is not to be given, it is a very rarity.
And they have to give proper reasons.
And reason, or else, my lord, there has to be a proper engagement between the Chief Justice and maybe the Chief Minister, something like that.
That is why in one of the cases, the Supreme Court appointed a committee.
Exactly. Recently, my lord, Himachal Pradesh did the Supreme Court has upheld. Oh, Lord, if your lordship, I'm just placing the law, my lord. Facts are appraised not in a very narrow compass. And this is 2004, 2 SCC 150. Yes. If your lordship should kindly come to para 42, my lord. At page 170. In Maharashtra versus Swenso, this court interpreted the provisions of Article 229 and the proviso appended thereto in the following terms. On a plain reading of Article 229, it is apparent that Chief Justice is the sole authority for fixing the salaries, etc., of the employees of the High Court, subject to the rules made under the said article. Needless to mention that rules made by the Chief Justice will be subject to provisions of any rule made by the legislature of a state. In view of proviso to sub-article 2 of Article 229, any rule relating to salaries, allowances, leave, or pension of the employees of the High Court would require approval of the governor before the same can be enforced. The approval of the governor, therefore, is a condition precedent to the validity of the rules made by the Chief Justice, and so-called approval of the governor is not in his discretion, but being advised by the government. It would therefore be logical to hold that apart from any power conferred by the rules framed under Article 29, the government cannot fix the salary or authorize any particular pay scale of an employee of the High Court. It is not the case of the employees that Chief Justice made any rules providing a particular pay scale for the employees of the court in accordance with constitutional provision, and that has not been accepted by the governor. In the aforesaid provisions, it requires consideration as to whether High Court in its discretionary jurisdiction under Article 226 of the Constitution can itself examine the nature of the work discharged by the employees and issue a mandamus directing a particular pay scale to given to such employee. In the judgment under challenge, the court appears to have applied the principle of equal pay for equal work, and on evaluation of the nature of duties discharged by the court stenographer, personal assistant, and personal secretary issued impute direction. In Supreme Court Employees Welfare Association, this court has considered the power of the Chief Justice in relation to the employees of the Supreme Court in matter of laying down the service condition of the employees of the court, including the grant of any scale, and observed that Chief Justice of India should frame rules after taking into consideration all relevant factors, including the recommendation of the Pay Commission, and submit the same to the President of India for his approval. What has been stated in the aforesaid judgment in relation to Chief Justice of India vis-a-vis the employee of the Supreme Court should equally apply to the Chief Justice of the High Court vis-a-vis the employees of the High Court. Needless to mention, notwithstanding the constitutional provision that the rules framed by the Chief Justice of the High Court, so far as they relate to salaries and other emoluments are concerned, require prior approval of the government. But this is important. It is always expected that when Chief Justice of the High Court makes a rule providing a particular pay scale for his employees, the same should ordinarily be approved by the governor unless there is any justifiable reason not to approve the same. The aforesaid assumption is on the basis that a high functionary like Chief Justice, before framing any rule in relation to service condition of the employees of the court and granting any pay scale for them, is expected to consider all relevant factors and fixation is made not on any arbitrary basis. So these are the underlying considerations.
Now, Mr. Chaudhary, have you looked into this judgment of the next one, the state of West Bengal one, in the paragraph 43?
The government will have to bear in mind the special nature of the work done in the High Court, which Chief Justice and his colleagues alone could really appreciate. If government does not desire to meet the needs of the High Court, the administrator will obvious certainly meet.
No. Have you looked into the entire judgment? This judgment is relevant taking into account their stand.
Financial grants.
Financial, that is the judgment which
So
says
there's
about the
another
fin-
judgment I have brought, my lord, where it says, in any case, whenever court issues any directions, my lord, there will always be an element of financial grant. I have brought the judgment, my lord, but
No,
that cannot
this
be a
is-
relevant consideration.
No, this judgment is relevant,
Yes,
taking into account that this matter was sent to the government says that no, because of the financial
Yes.
difficulty. The Supreme Court dealt with it, saying that financial difficulty cannot be the ground of that to that effect. However, there was an appointment of a special commission.
yes.
That is why I'm saying.
Okay.
Uh,
My lord,
let's-
recently, one more paragraph of the
Yeah,
judgment,
yeah.
then I'll come to it, my lord. So lordship will kindly come to para 49, the conclusion.
Yes.
Now please come to para 51. Having regard to the aforementioned authoritative pronouncement of this court, there cannot be any doubt whatsoever that recommendation of the Chief Justice should ordinarily be approved by the state and refusal thereof must be for strong and adequate reason. In this case, the appellant even addressed themselves on the recommendation made by the High Court. They could not have treated the matter lightly. It is unfortunate that recommendation made by a high functionary like the Chief Justice were not properly attended to, and the private respondents had to file a writ petition. The question as regards fixation of a revision of scale of pay of the High Court being within the exclusive domain of the Chief Justice of the High Court, subject to approval, the state is expected to accept the same recommendation, 7 except for good and chosen reason. The High Court, however, should not ordinarily issue a writ or in the nature of a mandamus and ought to refer the matter back to the central state government with suitable direction pointing out the irrelevant factors which are required to be excluded in taking the decision and relevant factors which are required to be considered thereon. The statutory duties should be allowed to be performed by the statutory authorities at the first instance. In the event, however, the Chief Justice of the High Court and the state are not ad idem, the matter should be discussed and efforts should be made to arrive at a consensus. This has also not been attempted. We are further of the opinion that only in exceptional cases, High Court may interfere on the judicial side, but ordinarily it would not do so. Even if an occasion arises for the High Court to interfere on the judicial side, jurisdiction of the High Court should be exercised with care and circumspection. But I have placed, my lord, all the pros and cons of the matter. Now, my lord, the issue is, here in this case, this is not the first round of litigation. This is virtually the third round. Now, eventually they say there is a financial crunch. My lord, I'll just rely on one judgment, my lord. That is again that All India Judges Association's case, 1994, 3, 4 SCC 288, para 16. My lord, this is the case where different directions are being issued from time to time, ever since 1989. Para 16.
The contention with regard to financial burden likely to be imposed by the direction in question is equally misconceived. Firstly, court do not from time to time hand down decisions which have financial implication, and government is obligated to loosen its purse recurrently pursuant to such decision. Secondly, when duties are obligatory, no grievance can be heard that they cause financial burden. Thirdly, compared to the other plan and non-plan expenditure, we find that financial burden caused on account of the said direction is negligible. Now, my lord, when it comes to paying this salary, I don't think it would be more than 1.5 to 2 crore per year.
No, last time I was taking up another matter. When Mr. Rajiv Baududari was appearing and Mr. H.K. Das was appearing. They categorically submitted before this court that they have agreed except that some PSP. What is that?
No. No, my lord. Kindly see, my lord. Now, sixth has gone, seventh is on the verge of going, now eighth. My lord, we are getting only their PSP, principal seat allowance. Pay, sorry, principal seat pay. If they otherwise pay, my lord, all right, we'll forgo this PSP, my lord. PSP was a palliative. Let us pay the equivalent thing, my lord, we don't want PSP. Now they want to pay us PSP instead of our dues. My lord, there is one recent judgment, my lord.
Now, Mr. Chaudhary, what
Yes.
is the direction being given in respect to this All India Judges Association, wherein there is specific directions being given
Yes, from time
now
to
for
time.
the state to pay?
Yes. Now kindly see, my lord, it's a case from Himachal Pradesh, my lord. Kindly see. We have perused the impugned order. The operative portion of the impugned order is at para 94 at page 64 and 65, which reads as under. In the light of the aforesaid discussion, we deem it appropriate to direct that this judgment be placed before the Honorable Chief Justice of this High Court to constitute a committee consisting of at least 2 honorable judges of this court, Additional Chief Secretary Home, Additional Chief Secretary Finance to the Government of Himachal Pradesh, Principal Secretary Law to the Government of Himachal Pradesh or any other person, Registrar General, Registrar Vigilance, Registrar Judicial of the High Court, and 2 other representatives of the Petitioner Association. The Honorable Committee shall go into details with respect to grant of
Mr.
high.
Chaudhary, what you are reading out here is what has been stated in that West Bengal matter.
Yes,
As I said to you,
yes.
that was specifically, if you look into the judgment of 2004 one assist.
Huh?
2004 one assist.
I said,
Isn't that the West Bengal case? Where there is a direction for forming of a committee.
That's their order is not a conclusive order. The final order is for 2017. May have placement. Final order is the last time of the order.
Which one?
That's 2004 one. Last time of the order.
I don't have the 2004 one assist.
2004, 1 SCC 334.
Final.
2007.
This is the where there is a direction. This is exactly on the High Court. In the instant case, the primary reason for refusal of the approval by the governor has been that the government's claim of inability to bear the financial burden imposed by the draft rules. The governor under Article 229(2) has the power to refuse grant of approval provided there is a very good reason for the same. It cannot be said that there has been no exchange of views between the Chief Justice and the state government. The correspondence between the state government and the Chief Justice commencing from 21/11/98 reveals sufficient degree of exchange of ideas. During the negotiation between the government and the Chief Justice, both sides expressed their respective views on the matter. However, there is no meeting point. The government will have to bear in mind the special nature of the work done by the High Court. which the Chief Justice and his colleagues alone could really appreciate. If the government does not desire to meet the needs of the High Court, the administration will face a severe. Hence, a special pay commission consisting of judges and AI shall be constituted by the Chief Justice in consultation with the government to make a report, and on receipt of such report, the Chief Justice and the government shall trace out the problem and work out an appropriate formula in regard to the pay scale to be fixed by for the parties. So this is what has been done in this order of by Himachal. Let this petition after the receipt of the report from the High Court. Where is that?
There are four particular paragraphs, but 10 and 11 and 12 is mentioned. There are four.
Then what happened?
There are 29 formats. The government created in the higher there are 29. We also find on basis for junction that all categories of employees are considered starting more onerous function than their counterparts in the state government. And of all high court employees without exception, therefore receiving a higher pay than their counterparts. Even in the absence of any general or special termination of pay, responsibility is that makes what supposed to enter upon. Suffice to say, a special pay commission has indicated the post by additional benefits and additional relief and accordingly granted to them. But then at least the general of the pay of all existing employees. There, my lord, the rule 4 was struck down. Struck down, no, my lord, they said that we will omit 4. That was the finally, that was the negotiation that has been, my lord, they stay and the, my lord,
So the question is here, there has to be a committee appointed.
Committee was there, my lord. In the affidavit, we have stated right from 2015, all these, my lord, negotiations were going on, my lord. There was discussion between the, my lord, the commissioner and secretary.
Have they submitted any report?
My lord, nothing, my lord, came, my lord, as good. So, my lord, there was a direction finally of this honorable court that, my lord, we must proceed. Against that, my lord, they preferred an appeal, the present petitioner. Now, in the appeal petition, there was again a direction that it should be placed before the government, and government will take a final call. And finally,
No,
the
no,
speaker-
I'm asking you. Did the Chief Justice constitute a committee
Yes,
in
my lord.
association with in consultation with the state government?
Yes, my lord. So you will see 1 or 2 reports we have annexed for them. There was a proceeding, my lord,
Where?
my lord, will page, my lord, 239. And 243. 242 also will see, in fact, the chief secretary was a member. And you continued, my lord, till the
The
final-
meeting of the Honorable Chief Minister of the Assam and the Honorable Chief Justice held on demand in the Circuit House. Now, this is the meeting. Now, increase in the judges' strength, allotment of vacant land,
Then
and
again, my lord.
allotment of temporary accommodation,
11-9.
allotment of 4 bighas in so and so, allotment of acquisition of private, allotment of 5 bighas, accommodation for finance land, I had agreed to allot land for.
11 will be 247. 247. It will be on this point, my lord.
This is another one.
Yes, 247, my lord.
The office of the Registrar General of so and so.
Division of pay scale and other allowance of employees of principal seat of the Guwahati.
Where is the judge? No judge.
No, my lord, because within the,
Then nothing.
so that committee, my lord, as per my lord, following my lord 2007 SCC, my lord, where special commission was constituted for West Bengal, pursuant to the honorable Supreme Court order. There was no committee, my lord, where the profit were there. There was no committee.
That is what I am saying.
In fact, my lord, what?
So the only way out seems to
Yes,
be
that can be done.
that when a committee is being constituted by the Chief Justice, of some judges, along with in
Yes.
consultation with the state government, their counterpart, to trace out why it has not been done, and then to submit a report before
That
this
will be
court.
my lord more friendly.
That is, seems to be the
And my lord, the
primary, this is how it can be done.
But
We
Lordship,
can-
kindly before that, Lordship, have a look at the speaking order, madam. Why, what at council and under this rejected? Just to madam point out, madam. Para, madam, page 264 for a moment, madam. Page 264 of the referendum. Continue, madam. 264. It is included in the present petition.
Who has passed this on?
Well, filed by the final part, the record the speaking order. It is also there in the petition. 264. Lordship will kindly turn to page 266. Just. Whereas the Employees Association has claimed pay parity with the employees of the High Court serving in outlying benches. The outlying bench of Guwahati High Court are Itanagar bench, Aizawl bench, and Kohima bench. Whereas the pay scale and allowance of the officers and staffs of the principal seat of High Court vary from state to state, keeping in mind the resources available of the concerned state. Whereas the officers and staff of High Court bench, as well as the officers and employees of Government of Arunachal Pradesh, draw as per the central pay scale. Officers and staff of the High Court bench, as well as officers and employees of the state government of Nagaland and Mizoram, draw pay and allowance as per ROP rules of the concerned state, depending upon the resource position of their respective states. Whereas the officers and staff of the principal seat of the Guwahati High Court draw their salary and allowance from the consolidated fund of the state. They draw pay as per ROP rules 2017 plus PSP, that is the principal seat pay. While the officers and employees of Government of Assam draw pay as per ROP rules 2017. Whereas the officers and staff of principal seat of Guwahati High Court are so far drawing pay and allowance in the following manner. Fifth Assam Pay Commission, Assam State ROP rules 1998. From there, my lord, they are enjoying, my lord. Whatever revision has been given to the state government employees from 1998 till 2017, they are enjoying. Addition to that, my lord, the principal seat pay has been given to them. Now, one vital point, my lord. Lordship will see, my lord, that fourth para, my lord, 267. One, my lord, one I'd like to point out. Whereas the Judicial Department has furnished additional financial implication only for the financial year 2015 and 16, which is stated to be around 4 crore something, involved with the proposed draft rules. As the revision of pay sought to be from 1/1/2006, my lord. And moment this is granted, my lord, the area that will come, my lord, the burden upon the state from 1/1/2006. They wanted the rules, even if it is today it is passed, it will have to be applied from 1/1/2006. That is ROP 2010. Then, my lord, the burden. That's why, my lord, this is one point, my lord, how, my lord, we cannot see, my lord, see through this prayer. As revision of pay is sought from 1/1/2006 as per the aforesaid rules, additional financial implication will accrue for this year, starting from 1/1/2006. The officers and employees of principals at Guwahati High Court due pay and allowance as per ROP 2010 plus PSP with effect from 1/6/2006 to 31/3/2016. So there will be a manifold increase in the total additional financial implication for the year from 2005-16. Whereas from 1/4/2016 to present, the officers and the employees of Guwahati High Court principal seat are drawing pay and allowance as per ROP 2017 plus PSP, and the total emoluments drawn as per Assam State ROP rules 2017 are more than what is claimed as per Guwahati High Court rules 2013. Moment, my lord, the 13 rule is approved, they will get lesser pay. It will go down, my lord. They are already enjoying, my lord.
Yes, from the so-and-so to the present, this was the impose of the-
Whereas the cabinet meeting has expressed the feeling that the provision of PSPS created disparity between the officers and the staff of Guwahati High Court and the other employees and staff of the High Court and state government, who also worked very hard and tirelessly to deliver different services to the public and work obtained in extreme of critical conditions like conducting relief operations, and so on. In view of the above premises and considering all aspects, particularly in view of the financial plan, the government in the finance bureau department with the approval of the honorable cabinet has having decided to allow the officers and employees of the Guwahati High Court to continue draw of pay and allowance as part of the 2010
with effect from 1/1/2016, 31/2/2016, and as per our 2017. From 1/4/2016 onwards, with the additional PSP as already allowed, instead of adopting the Guwahati High Court revised rule 2013 to avoid huge additional financial implication, which the Guwahati High Court revised pay rule 2013 entails.
Now, what is this Guwahati High Court revised pay?
Yes,
rules
that was
2013?
that was based on the
My lord, my lord, if your lordship would kindly come to page 155 and 157. This is what has been given here. 155, annexure A. Existing pay scales of 48 posts mentioned in part A, section 1 of draft Guwahati High Court revised are provided below. Here, existing pay scale means interim pay structure, pay band, grade pay, name of the pay band adopted by the Guwahati High Court for the officers and staff in the principal seat at Guwahati as per Honorable Chief Justice Guwahati. Now, for example, Registrar General Milord, existing pay band as per 2000 is so and so. So existing grade pay is so and so, and pay band is so and so. Now, at page 157, Milord, the revised pay has been given. Earlier, Milord, at page 157, the lordships will get both effectively. So revised pay band, grade pay, name of the pay band proposed as per draft Guwahati High Court rule. So earlier it was 26,000 to 45,000. Now it
No,
is
but
30.
where is the finding that these people are doing exceptional work for which they are entitled to get it?
It is there, Milord.
There has been a proposal.
It is there, it is there.
Because without that, can this court grant
Not
some
several-
separate pay? Because
several
otherwise they are
committees-
throwing the same pay.
Several judges committees were there, several, so many recommendations. Page number, if your lordship will kind of come,
Accompanied along with the proposal. They will have to justify the proposal with those grounds, that is that the ground for which this rule.
So that is not there till now.
no, my lord, I don't think the state has rejected on those grounds. State has rejected only on the ground that, my lord, it will entail financial, entail some financial expense. Now, on no other ground. Now, if your lordship would kindly come to page 160, my lord.
No, you see, Mr. Chaudhary, it
Yes.
has to be like this.
Yes,
Just for example, the Registrar General. The Registrar General pay band, if you come to page 154,
157, lordship will get both. my lord.
157. I
Yes.
say. 157, he has been put in pay band 2 or something, pay band 1,
Yes.
26,000 to 45,000.
Ah.
Now the revise is being sought at 37,400 and 67,000.
67,400. Yes.
Now the question is, with whom the Registrar General post is being equated?
Ah.
But-
That has been done. That exercise is there. my lord.
Okay, it has to be equated with some post.
Ah.
Now, against the equation of that post, now they want an increase beyond that post.
Yes. Yes. my lord.
What is the reason for it?
No, these are all done. These exercises were undergone, my lord. Following those exercises, only Chief Justice framed the rules. It's not that all of a sudden one fine morning it was done. Now, it all started in 2013. Today we are in 25. It's going on, my lord. It's not that all of a sudden, my lord.
No,
And you see,
understood,
there are-
understood, but then also you are getting the as per the 2017.
Yes. Yes.
You are getting as per ROP 2017, you are getting.
Yes.
But the question is,
At a lower pay scale.
no, you are getting it as per what is given to the state.
Yes.
Actually, as per taking the example of the Registrar General, the Registrar General should get further high pay on account of his work. So where is that justification?
That
How
is
do
there.
I
my lord.
get it?
That is there.
Yes, Mr. Mohanto.
What's the point, my lord? You have to kind of- They have not said we are not entitled, that employees are not entitled.
They say simply that because it is a
Because what Mr. Goi is saying, that after the formation of the committee
minor,
in the West Bengal case,
minor.
a report was submitted by that committee. On the basis of the report, it was stated that these are the persons who, as per their work, they should be getting a higher scale. And as such, the state had accepted it. But the state did not accept for everybody, which the court said that rightly done so, but some have been given. So the question now arises here, because normally this court normally can't issue a writ.
Minor. All the government
Absolutely within the prerogative of the governor. Now, governor means the state. So this court can't issue a writ, but the only thing which can be done is as to whether the reasons which have been assigned is right or wrong. Now, if the proposal which is being sent from the Guwahati High Court does not contain the reason as to why the Registrar General should be given not his particular payment, but something more than that, that is the basis of the justification. The Finance Act, the Finance Order does not refer to that. They merely say, that look here, what they are being asking, they are still equating their posts. Equating the post on the work done.
That will kindly come to page 112. There is a report. 112. Adequate pay structure for the officers and employees of the Guwahati High Court Principal Seat. This was submitted by Milord Surendra Mohan Deka, pursuant to the full court decision of the on the administrative side. Now the introduction says, in pursuance of the resolution of the All India Chief Justices Conference, the Chief Justice of Guwahati High Court was pleased to constitute a committee for consideration of uniform, better and higher pay scale of employees of principal seat as well as outlying benches of the Guwahati High Court. The report of the committee was forwarded to the government of Assam, Meghalaya, Nagaland, Manipur, etc. for consideration and acceptance. However, no acceptance report or communication was received from the government of the states. Pay Commission of 2008 for the state of Assam in its report did not make any recommendation as regards pay structure of the employees of the High Court, as according to it, its mandate did not include officers and staff of the High Court in view of the constitutional powers vested in the Honorable Chief Justice. Kindly see the contradiction below. On the request of the Guwahati High Court Principal Seat Employees Association, we allow the staff of the Guwahati High Court to draw pay and allowances as per Assam Services Revision of Pay Rule 2010. As interim measure, the Honorable Chief Justice was pleased to allow the prayer, and accordingly a letter was sent to the government informing that the staff of Guwahati High Court shall draw pay and allowances as per Assam Services Revision of Pay Rule 2010 as an interim measure. The Guwahati High Court Principal Seat Employees Association submitted a memorandum dated so regarding pay and allowance for the staff of the Guwahati High Court before the Chief Justice. Again on 11/1/11, the association submitted a detailed representation on 24 matters, among which was the matter of uniform, better and higher pay scale for the staff of the Guwahati High Court, enclosing earlier representation dated so and so. Pursuant to the above mentioned representation dated so and so, a committee was constituted to look into the matter. Thereafter, the committee decided to entrust the undersigned with the task of submitting the report on the matter of adequate pay structure for the staff of the Guwahati High Court Principal Seat. The decision of the committee on approval by the Chief Justice was conveyed to the undersigned by letter dated so and so by the Registrar General. This is now report is originated. Some materials considered. So these are the materials considered, my lord. Subpara in response to that report as to pay structure of officer staff of Bombay High Court, Rajasthan, etc., etc., etc.
Kindly come to page 116.
What? Yes.
So this seems to be some justification.
Yes.
As regards this, the financial benefits in
Yes. Milord, subparagraph 3, Milord. In pursuance of the order dated 7/10/2009 of the Honorable Supreme Court in WPC
that is the All India Judges Association case, in connection with Justice Shetty Commission recommendation for non-judicial staff of subordinate court of Assam, the state government of Assam wide notification has extended financial benefit in pre-revised pay structure, which was to be given effect to in the pre-revised scale of pay with effect from so and so. Thereafter, in the corresponding pay band, grade pay as revised in the state with effect from January 2006. That is why we are claiming from 116. As per Shetty Commission's recommendation, my lord, the subordinate court staffs are getting, we are not getting. Sorry, we means the employees are not getting. The financial benefit entirely includes revision of pay scales of certain posts, which has put some of the posts in a higher pay band and or grade pay than that of the equivalent post in the High Court service principal seat. For instance, pay scale of a stenographer grade 3 in subordinate court has been revised to the scale of rupees so and so. This scale, after a pay revision in 2006, falls in the pay band of so and so with grade pay of so and so. Whereas in the principal seat of the High Court, the post of stenographer grade 2, though falls in the same pay band, that is so and so, but has a lesser pay, grade pay of 4,300. Similarly, pay scale of the post of Sirastadar, additional district judge court head assistant, this so and so, and post of Sirastadar of district judge have been revised as so and so pre-revised, and 8,100 to 1325, which after revision in 2006 fall in the pay band of 4 of 12,000 to 40,000, having grade pay of 6,100 to 6,300 respectively, which are higher than that of the post of superintendent of the High Court principal seat. Post of the superintendent falls in the pay band of rupees so and so with grade pay of so and so. Obviously, the bottom line in an adequate pay structure has to be the pay structure of non-judicial staff of the subordinate courts in the state. The state government has been implementing recommendation of the Shetty Commission for non-judicial staff of the subordinate courts in installment. This has also created more anomaly in the
But,
current pay structure of.
But Mr. Chaudhary, this is an anomaly, the analogy is being drawn with the subordinate.
Yes.
But what about these various posts? Just for example, I'm taking our race agenda. Why there is this increase being sought to this? Where is the justification? So their answer to that is not on the question of equation as to why they are entitled to more amount.
But as far as Milord, the other staffs are concerned, it is based on chosen materials. I'm not talking about, Lordship is correct, qua, Registrar General and all. But regarding
They
the
are
other staff,
mentioning about those staff, the ministerial staff, where here these people are getting this much, whereas the subordinate courts are getting more.
there is one dichotomy, Lordship will kindly consider this. State says, since employees of the High Court, the pay commission cannot cover, so rules has to be framed under 229. They themselves say, Milord. Now, how can they say deny on both count, my lord? On one hand, they say you do not fall under the purview of ROP. On the contrary, it is your stand. It is the Chief Justice who is the competent to frame the rules under 229. And when Chief Justice frame the rules, you don't approve it. It can't be. Someone
Mr. Chaudhary, I have two persons from the Guwahati High Court who are there in the council. So they informed me that in 1964, there is an order of the governor which says that whatever the amount these persons are going to get, the state government, this will be paid to the Guwahati High Court. It is on the basis of that order of the governor going on. This is going. That is how we get it, although there is no equation. But the question is how a person is to be equated, how much a person is to be equated. This is absolutely the role of the Chief Justice.
No, my lord. Here, because RO revision of pay rules cannot cover the High Court employees, therefore Chief Justice has to frame the rule. Chief Justice has framed the rule. If you don't want to approve it on ground other than financial grounds, please indicate. That you have not done, my lord. Only financial grounds cannot be a ground, my lord.
No, financial costs they have said, but there has to be a justification as
Exactly.
to why you require the Registrar General to get
No,
this
sir,
amount.
the cause of action arose because of the recommendation of the pay commission, sorry, Shetty Commission.
Now, SETI Commission recommendation has been accepted by the government as far as the staff of the subordinate courts are concerned. But as far as my lord principal seat is concerned, they have not.
No, they are entitled to, there's no quarrel that they are entitled to as per what is being given to the subordinate court. There's no
Yes.
quarrel with that.
Yes.
Because that is the itself their stand also. That we are giving what the judicial employees of here and there, we are giving the same.
No,
We-
we are not getting, my lord.
Yes, that is not getting is another aspect which this court will deal with. But their stand is that we are giving. But what they want is something more. And referring to the judgment of 2017, they say, therefore, that there was a committee being framed in the 2014 judgment, and on the basis of the report, wherein the government had accepted some, the government did not, but the acceptance is on the basis of the suggestions being given by the state, by the Guwahati, by the Chief Justice or its committees, that this is the amount, this is the work for which they should get. Without that aspect coming into light, how can this court pass any order? That is the problem I am facing. I hope you are getting understanding.
Yes,
this.
yes.
And I have to also look into my limited role with those
No,
observations
my lord,
being
there are
made.
ways of looking at it. Either, my lord, there should be an engagement at the two highest level and sort it out. That is also one way of it.
So why not? We have, I asked the Chief
Oh.
Justice the constitution of a committee.
Yes, that is also possible, as Himachal High Court has done.
High Court has done it, which was done, therefore I'm saying Himachal has done in terms with the 2014 judgment.
Yes,
And on the basis of that, that committee will deliberate with the state counterpart
yes.
and go into the question why they are actually entitled to more. Now, if you see, there's another judgment of Mamutha or something, 2013 or 14, wherein it says that this is the absolute power of the Chief Justice to see as to what is the work he's done. But whatever may be, all these amounts are therefore to be paid from the consolidated fund of the state.
Yes,
So
absolutely.
it will be charged, and you cannot lessen the amount also later on. So we have to think about that for the state as
But
well.
as has been done in case of Himachal Pradesh, that can be adopted.
So that is the, I think, would be a better option, and for directing them to submit a
But not
report.
give a time frame.
Yes, yes.
We are fighting for quite some time.
I think, what do you say?
That is what all the judgments say. In none of the judgment, there is a specific direction to the government. to approve the-
No,
They say
that,
it is together.
that, Mr. Gogoi, I hope you understand that I know that. No, that I know. I cannot. I know that I cannot, but therefore the only way out is
Yes, yes.
to find out where the problem arises and a report being called. Anyway, let us rise.
My lord, some justification is there in page 57 also.
Mr. Chaudhary, we
Yes.
here at two.
Yes. Look, there is a meeting with the Chief Justice now. If I'm late by 10-15 minutes,
No,
not
it's
to
okay.
exceed.
So
Otherwise,
if
I'll try to come.
If the meeting with the Chief Justice is delayed, I will also get delayed. Okay, we take up this matter later. First, let us take the other matter. Yes, finance, what questions you have put?
Yes, my lord. Just sometime ago, my lord, in the course of the day, my lord, I have received that communication from my learned colleague.
Which one?
My lord, that I have placed it on record. On the last occasion, Lordship has put a pointed query to the extent, my lord, that what was the queries raised by the finance department with regard to, my lord, framing of that draft rule. That these are the queries, my lord.
There, my lord, in the last few pages, lordship will find, my lord, the ROP has been amended to the extent, my lord, on the last occasion, lordship has put a pointed query to the extent that, my lord, now new dimensions of jobs have, my lord, come in. So with regard to that, my lord, lordship will kindly see, my lord, so far as the subordinate judiciaries are concerned in this establishment, my lord, these posts have been, my lord,
Yeah, now what you want first is that the draft service rules should be made in consonance with the notification dated 35/2020.
35, 2000, yes.
That is what you want.
This is the cadre wise, my lord, pay structure.
You say that instead of you have in the draft rules you have put ABCD or 1, 2, 3, 4. It should have been only ABCD.
The schedule. Say, my lord, normally that nomenclature is followed, my lord, in ROPs.
The third is the payment of some of the scales are not as per the latest band. So as 35/2024 holds the fee as of now, the payment has to be in terms with this only. And then the executive engineer post is not mentioned in Schedule B.
Yes. But there, my lord, the same,
Because
my
I don't think in the district service rules, you have put the post of an executive engineer. And post of executive engineer, you have put in the service rules.
Executive assistant.
Or executive assistant to the district judge. What is that post? And the fifth is personal attendant. Where is the draft service rules? Can I have it? So you want to make this temporary post, temporary employment in terms with the appointments which are to be made within the ambit of the service rules. You want to make these temporary ad hoc appointments within the ambit of the service rules. Serial number 24. Kindly come to page 185 or 134, whatever may be. You want to make it a part of the service rules. Why?
Establishment is based generally, and if it plays before the rule committee, and thereafter it is clear.
This doesn't seem to be the answer.
The answer. This is a prime officer concerned section which has been put up before the rater establishment. Now, delegate make rater establishment rater general, and a final most of them take the rule making committee, and rule making committee's approval, then it will be forwarded to the government. But prime officer you also will see.
You have made another draft, District Service Rules 2024.
This is after the correction that will also find in the government record, I guess. After the 2018, thereafter some corrections were made, thereafter this 24. There is the record.
Now, in the 2024, you want to bring in the post of accountant.
Account. Because it was created in between. Plus, 2-3 cases are pending here because there is no equivalence made with the post of accountant and LDA. Next promotion post is head assistant. So, as because there is no equivalence, so the
But
accountant
whether it was the accountant was there in the draft service rules, no.
has to be there. So it was created in the year around 2019. Yeah.
There's no accountant here. This must have been subsequently.
Yes.
So now you want to include something more.
That accountant.
What accountant? Just accountant. There's others also.
Yes, so far as prime officer, uh, the post of executive assistant.
Now you want to have this record keeper, record arranger, and protocol attendant. They were not there. So now you want to include those.
Yes.
But are these posts actually created or not? No, whether, you see, the state would have no problem if the posts have already been created.
These are already there.
The state would only have a problem if there is no post created. You can't have asking for new posts created in the name of the draft service rules.
Record people, record arranger post is already there. These are not new posts. The ROP rule also.
Now, I could see out here, it is there in this particular thing.
Yes. There.
Now, this document which he has given me just now,
Yes.
it could be there. Accountant is there. At on 34/5/2024,
That
accountant is there.
The post of accountant figures in the ROP rules.
ROP. Then you have the record keeper, protocol officer,
Yes, protocol officer and
all these are
the
there.
last locator lordship was
Record arranger, these are
recorded.
there.
And so far, as my lord, considering the new societal changes, my lord, that new posts have been created owing to my lord various needs. So lordship will also find my lord the computer typist. These are technical posts, my lord, in that ROP. Computer typist will figure at my lord serial number 20. Then my lord serial number 25 lordship kindly see system assistant. These are all my lord new posts with new dimension.
So there is no creation of new posts, but there is inclusion of them in the draft rules. Now, the moment you are bringing in an accountant, wouldn't there be a corresponding entry in the main rules? Yes, these are recruitment rules. So these have to be brought in. So what are you doing?
This is the, your service.
No, whether they, for the post of accountant were never there in the draft rules of 2018. Now you have another rule of 2024.
It's also a draft.
Understood.
Correct.
All are draft. After 87, everything is draft. So now you have another rule of 2024. Now, have you given it to them or not?
Yes, it's with them, has been forwarded to the government.
Now, have they taken the decision on the basis of the 2024 rules or the 18 rules? And where is the 2024 rule?
Lordship, in the bunch of papers which I have given, my lord, their lordship will kindly see in the first page, finance department, my lord, endorsement is dated 15th of February 2025.
ওই কাগজখন ক'ত গ'ল এতিয়া ইমানখিনি আছে handful of 15th of
Yes, in the bold letters, in the first page, my lord, the last line with bold letters, kindly see. This has been communicated with the views of finance establishment A department by their endorsement dated 15th of February 2025. So what materials were, my lord, produced before the finance department, my lord, to that extent, my lord, I am not aware. But this is the date which the endorsement was issued.
no, they refer to the it is in view of the above. It is requested to kindly consider the matter and if found just and proper to incorporate the aforesaid observations of the finance department in the drafts Assam Service Rules of 2024
That's what.
for taking necessary at the end. So in these draft service rules of 2024, you have not mentioned the accountant. What did you do? I gave you so much time.
I think accountant, it's time to get.
It seems that you are not interested. The High Court is not interested. It seems so. The Guwahati High Court seems to be not interested in this. So better off I allow their petitions. What do you say? Their petitions, I allow it. Then you go to whatever you feel like doing it. Why should I trouble Mr. Arbo with it? Because it seems that the High Court is sleeping. Can't help it.
They have, so just now,
They have not woken up. They have given you. You have to be, you see, you are the person under 235 to take care of it. You are not taking up the issue seriously.
records that we
It was sent in the month of February. The judicial department have sent that letter. What are you doing? We are in the month of March. Does it take such a long time? What is this putting up? Don't you think that this should be taken with foremost urgency?
the register vigilance, I have requested him that to finalize this within a week. Whatever meeting is required to be held,
between him and the registrar general and whatever,
Should be placed before the chief justice,
Exactly.
the 235, it is 235, then obviously chief justice alone doesn't have, it's the high court.
yes.
So the high court has to, it has to be placed before the high court to immediately do
exactly.
whatever it is and send it there. But it seems,
I requested him that he place it immediately because lots of litigations are going on because of the.
yes, Mr. Vivas. What is that, sleeping?
I understand.
I think the good,
slumber.
sleeping horse or something does not gain or something to that effect.
I know.
It applies to the high court. That
Because 24 rules might not, we are also not privy to because that is not in public.
it is
domain.
the same. They have
The
not
same,
changed
but then I
anything.
think some additional posts that were created in between 2018 and the initial.
So now they
They
have
are thought to
changed.
be-
He has also placed before this court the 2018 rules. Now we are in the year 2024. Fine. We have to still going on with the 2020, 18. 18 has gone for a 6. Now we have to go for 2024. Okay, we have it next week. Give your inputs, ask your register to give all these things. Do the needful. Within a week means this week. Only is tomorrow. And then on Saturday it is open. So I open, ask your register to do it. Second or third Saturday. Let them do it and then proceed before the rule making committee. And then we'll look into it. Should I record it about the laziness of the High Court?
Okay, good.
It is because of this, rules are not being made. What is happening is the subordinate judiciary is making a minimum qualification criteria.
Yes,
In the
the
name
other
of
day Lord
seniority.
was speaking about that.
They are having 80%, 70%, 60%. One has to qualify, then they will be considered.
Only that, there are some factors wherein, there is no clarity and because of that, whatever is there in the mind.
Clarity will only happen if you do it. You have given urgency, like finances, issued that letter, you have to reply pinpoint to that effect, yes. As regards 1 and 5 and 4, I don't think the 1, 5 and 3.
Yes.
1, 2 and 5. It doesn't seem to be anything, there's no,
Executive assistant,
uh,
it's already, you have been explained that the post of executive assistant, so it will not be mentioned post to mention the ROP 2017. So the judge shall choose from among the stenographer grade 1 to work as executive assistant. So same may be deleted from the draft service. There is a consensus with regard to maximum, one or
only thing is, only seems to be some problem is the personal attendant. Now, personal attendant, if you are bringing him in the rules, it will have serious consequences.
say, maybe deleted.
It has to be, otherwise tomorrow, because personal attendant would be temporary. You are not going to have any process, recruitment process. Now, without a recruitment process, you bring him, and then tomorrow he comes, I have done as per the rules. It will have far-reaching consequences.
That's why I
Ah.
think temporary post, same may be deleted from the draft service.
Fantastic.
There is some.
One good idea as well.
Or they can outsource also.
Huh?
They can outsource also.
No,
Also,
no,
because
it will have a serious consequence with this personal attendant business being brought in within the ambit of a service. You may have a notification to that effect. A person may be entitled to, a judge may be entitled to some personal attendant for which he may choose or they may give whatever may be. But this has to be given on a temporary basis, otherwise it will have, because on the other hand, you write it as temporary and you know what will happen thereafter.
Heavier of this memorandum of the year 2012, which specifically states, they have
That is for sweeper. We are not with SEPA, we are
My lord, I
personal.
understand that, but similarly, my lord, this post can be earned, because these are, my lord, on and off. This
No,
not a
they
regular-
may be entitled to a personal attendance. For which an amount of rupees, this might be given out there, that is a different thing. That is, for that you may have it in the service room itself. But to create a post within that will have far-reaching consequences.
That has already been denied.
Chalo. It has been Heard Mr. Arbor Pujari, the learned counsel, appearing on behalf of the petitioner, finance department, who submitted that at the request of the finance department, the judicial department of the government of Assam had written a letter to the Registrar General of the Guwahati High Court on 24/2/2025, indicating certain observations of the finance department to the draft Assam District Court Employees Service Rules 2024.
My lord.
Pusto. To the said aspect, this court inquired with Mr. H.K. Das, the learned counsel appearing on behalf of the Guwahati High Court, as to what steps have been taken pursuant to the said communication issued by the Judicial Department of the Government of Assam. He submitted that the matter is being looked into by both the Registrar General and the Registrar Vigilance. And in that regard, the necessary report proposal would be submitted by the registry before the committee. Committee formed for the purpose of deciding the rules. For committee so formed for the purpose of deciding the committee so formed by the Chief Justice for the rule for rule making. He submits that some time would be required in that regard. List this matter again on 27th of March 2025, on which date Mr. H.K. Das shall place before this court as to whether any communication has been reverted back to any communication has been issued by the registry of this court to the judicial department in reply to the communication dated 24/2/2025. You take this, I don't require this.
Lordship may retain that bunch of papers, my.
You want it?
No, but lordship will keep it as a part of the record market.
এই রেকর্ডও যেটা বুঝতে আছে একটু রেকর্ড করে দেবে আরো তো যে বেশি নষ্ট হতা হ্যাঁ এখনো রাখি তুই দিবি I won't mark it with records, yeah.
And so, like,
My lord, we have discussed the issue with our clients. My lord. They want some time, my lord, to revert back. 1 week time may be given, because end of the day, it's an association's case. So they would like to have a discussion among them.
Because Mr. Chaudhary, the problem which has happened, although this matter shouldn't have gone till 2025
Yes,
without forming that committee, unless this is being delayed. First, there has to be some discussion amongst the stakeholders as to why it is required.
Correct.
And on the basis of that, some report has to be placed before this court.
it is
On the
there,
basis-
but in a scattered form. It is not there in, they would like, also like to have the, my lord, consent of their other,
You take it.
after a week's time, my lord.
এই দুখন terms দি দিব।
Lordship
These-
can have
these
it on 27,
two take it in.
27.
Third, Mr. K. Chaudhary, the learned senior counsel, assisted by Mr. J. Patwari and Mr. B. Gogoi, the learned counsel who appears on behalf of the Finance Department of the Government of Assam. While hearing the matter, a question arose as to whether in the proposal so submitted, along with the draft rules of 2013, there was any justification given by the registry for the purpose of registry of the Guwahati High Court, for the purpose of enhancing, for the purpose of having a higher scale of pay, or for the purpose of proposing a higher scale of pay to the members of the to the officers and servants of the Guwahati High Court.
Principals.
Principals. No, 2013 is for the principals.
Yes, principals.
For the, yeah, for the officers and servants of the Guwahati High Court. Insofar as the, for the principals. Mr. Ken Chaudhary, the learned senior counsel, submits that he's being instructed by, upon being instructed by his counsel, his assisting counsel. Some time it will be required to go into those aspects. Just list this matter again on 27th of March 2020.
Diploma.
Item 10.
Yes, Mr. Bolwa.
Well, this matter also more or less same, it can also come on 27.
According to the recommendation of the.
Here,
Affidavit.
the court officers are paying parity. Court officers are paying parity with the serestidar of the subordinate court.
Same line,
Basically, same issue
same issue.
with regard to the. So far, we are concerned, my lord, we have already forwarded the representation to the government.
But
Now,
here,
government is to take a call.
and the government has not filed their affidavit also. in this case.
Finance. Finance is the main person. You don't want to oppose, I suppose. Mr. B. Gogoi submits that affidavit is to be required to be filed by the Finance Department, taking into account the notice was issued on 11/11/2024. This court fixes this matter again on 24th of April 2025. Full stop. In the meantime, the Finance Department is given the opportunity to shall file their affidavit by 21st of April 2025, on or before 21st of.
Diploma.
11.
Here, again, the same issue, seniority cum merit. My lord, I have received the instructions. It contains only the minutes of the selection committee meeting. It doesn't have the minimum mark that has been fixed by the selection committee. As
Item
well as
11.
the marks, my lord, secured by the candidate. So I have already written a mail to the district judge, my lord, or to the registry to get the records, my lord. Otherwise, things are will not be clear.
Mr. Iskedas, appearing on behalf of the respondent authority, submits that he would like to file an affidavit.
Yes, sometime will.
Which accordingly lists this matter on 24th of April 2025. The affidavit will be filed by 21st of April 2025. In addition to that, the counsel appearing on behalf of the respondent shall also produce the selection, the minutes of the selection proceeding, including the connected papers.
Yes.
Next day. You have filed your affidavit. Ms. So-and-so also appears, who submits that she would file the affidavit on behalf of the respondent number 6, 7, and 8 on or before 21st of April 2025 without fail.
For orders, item 12.
Here, I need some time for filing affidavit. The reason is that, the learner CBA just, he's not there. So my instructions could not come. I have in fact received a letter.
Oh, this one.
Yes, Milo.
I didn't grant the stay.
Yes,
We are
Milo.
paying for the respondent, service complete. Acceptance are filed by the learned counsel for the petitioner after serving copies of the. You have served it.
Yes,
You have served it also to.
the private respondent.
So we pass an interim order.
Need to file the affidavit, Lordship will allow me to at least place the, because I don't have nothing, I have
We'll
nothing.
consider the interim prayer on the basis of the instructions to be obtained on the next date without fail.
The today, I am handicapped because I don't have the instruction, because the concerned judge, I think he has been transferred and someone new will be appointed.
Which district?
This is special judge CBI and NIA, Assam.
Where? Guwahati?
Guwahati. It's Guwahati. So this is
Special Judge CBI and NIA Assam does not come within the jurisdiction of the district judge. Does he come within the jurisdiction of the district judge or not?
I think it is equivalent to,
Because he has been
Equivalent to the
appointed as a solicitor, no?
yes,
Solicitor of
special judge CBI Assam Guwahati.
The person who was constituted election to the area of the district and session judge. We are concerned with the solicitor, district judge.
No,
Has the district judge of the Guwahati, Kamrup have changed?
it's
No, this
appointment order,
person has been appointed what? What is the impugn order?
page 45.
Comes into force of So there is no person who is involved in the special judge CBI.
Exactly, that is my instruction below. So some time I have been asked to pray, and in the meantime, I'll get the instructions.
Mr. H.K. Das, appearing on behalf of the respondent court, submits that some time is required for the filing the affidavit, as the post of the special judge CBI and NI Assam is presently vacant. He is presently, as there is no new, as the submitted that some time is required for filing the affidavit. He submits that he could not obtain the instructions, as there is no regular special judge, CBI and NI Assam. So taking into account the above, list the matter on 24th of April 2025. The affidavit be filed by 21st of April 2025 by all the respondents. It is further observed that on the next day, this court will take up the instant proceedings for final disposal. If it cannot be disposed, this court shall consider as to whether any interim order can be passed.
Deeply.
For hearing item 13 and 14. Part time.
Lords, I appear for the appellants, in both these matters.
Yeah, we have it some other day. You are in a very hazy atmosphere.
Yeah, my lord, I'm sorry, my lord, I got injured. So, my lord, can it be
I've
subject
heard
to
that your legs have been broken,
yes, my lord.
leg fracture.
Yes, my lord, I'm in a difficult situation. Lordship, may if I may pray for 8th of April, my lord.
Tomorrow you say, if I dismiss your appeal, then say what he has done, he have even not considered that I have broken my leg in
No, my
trying to
lord,
satisfy this court.
no, in view of the substantial question of law that your lordship has framed, I don't think that these appeals, my lord, lordships will dismiss with great humility, my lords. And my lords, may I pray then for 8th of April? I will try to attend in person, my lord. I will recover by that time.
But anyways, I won't be there. Is it parted before any?
My
No,
lordship will keep it parted any date, my lords. It has been kept parted.
but I am not there. This is for further hearing it is given. So
Yeah.
then I think I have to fix it after that because
Yes,
I
yes,
will be
lordship,
coming
yes,
back
yes.
on 20, joining
Then-
only on 21st.
Yes, my lord.
I
After
will
that.
be here for the first 2 weeks. Okay, Mr. A. Ganguly has appeared to video conferencing mode. Was taking into account that he has fractured his leg. This court is and is in not this court would adjourn the instant matter to be taken up again on 22nd of April 2025 at the top of the list.
Lordship. Deeply available. I'm sorry.
24th not possible. Then it will be on 29th of
29th.
April 2025
Yes,
at the top of the list.
deeply obliged.
I hope by then your leg improves.
Plus, I will come with crutches also if necessary.
Don't come.
Deeply obliged.
15.
Yes.
Wait, Lordship. My lord, I'm being led by senior counsel Sharma. My lord,
Who?
AC Sharma, my lord, is leading me in this case, my lord. My lord, he is
Who is your senior counsel?
AC Sharma, Atul Chandra Sharma.
What happened?
He's stuck up in the court, my lord. My lord, can for a time being, my lord, can not.
Anyway, chalo.
But
Concurrent?
not concurrent,
We got them, but even though the substantial question of law which has been framed based on the finding of fact, and land is a path. Land is schedule 2 is the path. I have purchased land from the vendor, and he has also purchased the same from same vendor. In my land, it is not in my cell deed. There is an provided path 7.5 feet provided by the owner, and 7.5 feet from my land. So 15 feet path. He enclosed entire 15 feet path.
And he has a sale deed for 15 parts.
No,
My field is prior to
there
that.
are my cell deed, his cell deed is prior. There is no path mentioned. When I have purchased from the land of the owner, there are area more than 1 bigha or more land. I have purchased only 4 katha, 8 katha. And he has
Now,
purchased
does the first appellate court hold that your land, that the 15 feet path is a part of your is a part of your sale deed?
yes.
That is a
the
finding of fact.
Finding of fact, and the exhibit 1, which I have proved, that from that also it has
Irrespective of there being a sale deed.
sale deed of exhibit A.
Irrespective of a sale deed, it is a finding of fact
Fact,
that there is a 15
15
feet
feet
path
path,
inside your land and which does not affect 48.
Yes.
There is a finding of fact.
finding. Nothing. And his sale deed
Withdraw?
also proved.
My lord,
Withdraw?
my lord, Sharma will come and address this on the report because my lord, probably this, I humbly submit, my lord, for a possible for a timing, my lord, he will come and he will address this on the report. Please, just back up in the court. my
And
lord.
the
What
question
is the interim order you have got?
Interim order is in his favor, my lord. There is no interim order as such.
no, I have find, after admission of this case, he started construction over the path. I filed injunction petition,
You got an injunction.
injunction.
So you are using it.
This
No,
path, no,
that
there
is
is a recovery of, in the plane, there is a recovery of path also, 15 feet path. He is encroaching this land, but he started construction during pendency of this appeal. So
So you got an injunction.
injunction, yes. So construction has been stopped.
So there's some 15 feet, 7.5 feet of land of yours have been encroached by him.
Not only 7.5 feet, the 7.5 feet which has been given by the original owner, that also encroached.
my lord, I just pray, my
And
lord,
this
let
path
it be,
for the common use of the plaintiff and the defendant,
is
Not for the common use.
not for,
for common use. Jointly by the defendant and respondent. It is not only for the, my purpose.
So it is being given to him and you.
No, there is no mention. But
So
in my
you are
pleading-
mentioning some defendant and respondent, common
it is-
use.
in my pleading, it is stated that this path should be kept it as a common path.
For you and him to use it.
Yes,
But he cannot encroach upon it.
he cannot enter.
my lord, will possible for timing, my lord, I'll just call him, my lord.
And the substantial question of law which has been framed and is see. And
Lord, if-
Anyway, today no second appeal day. When do you want it?
Lord, any date next week, my lord, can, is convenient to this suitable court, my lord.
Why do you want the dismissal in my hands? It's going to be dismissed. Your senior comes on, doesn't come, it makes no sense. Only it is only the putting of his name as A.C. Sharma, we can put it in dismissal.
Sir, one minute, Mr. Sharma is. He is in. He's on the way, my lord, my lord. Otherwise, my lord will.
Okay, when do you want it?
My lord, please, any date, my lord, is convenient, to my lord.
I am
My
not
lord.
convenient with anything. place this matter on. When?
My lord, if it is on the last part of March, it is around 27th March, my lord.
Because my
Okay.
path has been,
Today is 11, what is the date today?
Today is 13.
Thursday, na? Okay. Who thought taking given cases?
Maybe on 20th, my lord. On 20th Thursday, the next Thursday,
28.
20.
No, Thursday is actually not for your
High Court
High Court matter. April, no, May, March. Well, 28 তারিখ হয় before 16 March, Ostas. Now, top of the list আছে March.
My lord, this is survived.
Yes.
Well, the short point involved in this appeal is this, my lord. Whether the vendor of the plaintiff and the defendant can sell the, whether the vendor of the plaintiff, whether the vendor of the plaintiff can sold the land which already sold to the defendant.
Now, tell me, what is the finding of fact?
Finding of it is a reversal, my lord.
Huh?
It is a reversal.
No. What is the finding of fact on that point?
That point, trial court held in our.
Final one. What is the
Final
finding of
findings.
fact on that point as to whether the land which was sold to you was again sold to them, or that land of common path of 7.5 feet and 7.5 feet which is to be maintained is not a part of your sale deed? If that is the finding of fact, how can I touch? Unless you say perversity.
No, but your lordship kindly look to the paragraph number 10 and 11 of the appellate court.
No, Mr. Sona, my specific question is this. If it is a finding of fact to that effect, that land is not a part of your sale deed, or that land has been kept as common without affecting your sale deed, then in that regard, it is a finding of fact, unless it is a case of perversity.
It is a case of perversity because the learned law appellate court has failed to come to a definite conclusion that this 15 feet wide path runs through my land to the western side.
No. Did it come to a definite finding, that this 15 feet land, half of it was common and half of it was left out by the owner and half of it belonged to him? Is that a finding of fact? Let's see that. If it is there, the matter is over.
Before that, can I,
Let us see the impugned judgment.
okay, before that, my lord,
You
can
filed your counterclaim.
counterclaim on such email.
Your counterclaim dismissed. Yeah. Whether the plaintiff has got right of use and enjoyment, that should be exhibit issue number 4. Issue number 4. Was the first appellate court judgment. Let us see. First appellate court judgment. The plaintiff instituted the suit for declaration title in man of the one. It is the case of the plaintiff that he has become the only possession of the ship. But she certified copy of exhibit 1 by the exhibit B. Now is discovered by You did not challenge the sale deed.
I have not challenged this because I got my land. Land and I am in possession of the land. So I have no dispute with this.
But he said it had mentioned about the 15 feet path.
15 feet apart from the 7 feet 6 inches from the tender and 7 foot 6 inches from the
Of his land.
therefore that then cannot go through the my land.
So
To the
if you don't challenge the deed,
No, we have not challenged.
so if you have not challenged the deed, and you have filed a written statement also, a counterclaim also not challenging it, thereby you are giving up all the rights in respect to the challenge to his deed. Can you maintain it? Where it is being mentioned that they either had a boundary of 15 feet.
No, he cannot claim the 15 feet wide path from the main road to the western side, that is the Langai Kham, because it is through my land. He could also
No, as per a reading of the sale deed of his, does the
Yes,
15
he said
the-
it, yeah,
does
yeah.
the 15 feet road go inside your through your land? Because you have, as your evidence shows, that you have given evidence to the effect that you in 2006 you have taken possession, and thereupon you have bounded it with walls. So the learned court said that there cannot be an encroachment upon you because your boundary has not been broken. That is your evidence. So your counterclaim was dismissed on that ground. Now, you, as regards the path, you did not seek for a declaration that this path falls within you.
That we have not challenged, but our case is this: the the road as alleged in the plain. That road cannot come to the western side. It is the
No, but does it come through the same on because of the sale deed?
So that sale deed is only to the effect of 15 feet up to the land of the defendant.
After the land of the
Defendant.
your land.
Well, I have a picture if you can see.
Who is Pran Gopal Sinha?
Appellant. Dependent appellant.
And what a Palak Dev is who?
Plaintiff.
Now, where is he claiming here?
He is claiming from east to west that 15 feet part through the land of through my land.
Means to come down,
Come down to the western side.
thereby reducing the area of his land, your land.
Yes.
And what does the sale deed say? Let us see what is it. Let us see his claim. What does it say?
It says in my northern side, 15 feet road.
No, no, no. What are you asking?
Feet one.
East, Ratna, Chakravarti and Port. No, no Chakravarti and Port. West, Rain and land of the same dog. Not scheduled to land. Okay. South land purchased by Srimati Nileswar Sinha. Now, let's see the sale deed. That is only the question. If the sale deed has stated that it is only up to the path of the defendant's land, does it mention anything?
It is mentioned 15 feet wide.
Nothing. The 15 feet wide path is still where?
allot it on up to the western side, Langai.
Which means your part of your land has been given.
Land is up to the up to my boundary. only.
No, I'm saying you are in this diagram, this Palak Dev is the purchaser, na? He's the plaintiff.
Right.
Okay. Now, if in this land, it is a 15 feet, is the entire land on the north of Palak Dev
Yes.
and does not mention anything of the defendant's land.
Doesn't say anything because
No, if it does not mention, that means he has executed a sale deed in respect to the defendant's land also. Your land also.
yes,
Because the boundary therefore should have been mentioned that part 15 feet and part so and so. So what he did, he sold the entire thing.
and that is my lord, the actual real picture is this. The vendor sold us to earlier. After my sale, he purchased the land. And he knew that we are in occupation of the land. Even though the land was stated in the order said 15 feet wide point.
So as per you, this 15 feet. Was there any commission done?
Survey commissioner was not paid for.
Huh?
Survey commissioner paid for in the trial.
Then what do they say in their report?
No, not paid.
There the problem. Because if the learned first appellate court had come to a finding that there is no encroachment on the part of the defendant land from the year 2006 when he had already covered the land, then in that regard, can it be said that your 15 feet will encompass right from the road till the Nala? How do you take care of that situation?
Can we see the cell deed, my lord? Cell deed is very much clear, my lord.
What does it say?
And counterclaim also, he only paid for 1 feet. Not 7 feet or 15 feet, anything. Only 1 feet in counterclaim.
No, that is okay, but I'm asking you, you see, in your plane,
My claim as well as my cell deed, as well as vis-a-vis the cell deed of
exhibit 1 is whose document?
my
No, exhibit 1 is
cell deed purchased by me.
so to your land on the east is Ratna Chakraborty, isn't it?
Ratna Chakraborty.
Yes.
Then west is Nala and land of same Dag.
ওই দাগের জমি, another, other. Then উত্তরে বর্ণিত 15 feet
Narrated 15 feet road.
and দক্ষিণে 14 তারিখে registry of.
Now, in this particular plot of land, you were sold 4 katha, 8 lechas.
I have purchased.
You have purchased 4 katha, 8 lechas. Now, these 4 katha, 8 lechas included 7.5 feet.
In from my part.
What is the length of this feet?
Length.
And what is your boundary? Is it mentioned anywhere?
Exhibit 2 as well as exhibit 8.
No, it's okay. Anywhere written anywhere? Yours is not. Where is your boundary?
I don't,
His first appellate court could have written the judgment properly. Where is your boundary? Anywhere mentioned? You don't have a boundary, so he's right. Let's dismiss it on that ground.
no,
You have not mentioned the boundary. How can your counterclaim be without a boundary?
one of the exhibit is
I think better you go to Supreme Court. We dismiss your appeal. You have not given the boundary. Where's your boundary of your land? Nowhere it is there. Neither in the plain nor in the written statement, not or your counterclaim. Nowhere.
already cell deed I have exhibited.
So
The boundary is there.
we are in second appeal. We should not look into the same thing. I'm not sitting in first appeal. Without there being anything, why should I? We should dismiss it. Right away.
But the,
No, 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 no.
logically saying,
I am not going to look into the sale deed. Why should I look into the sale deed unless you have pleaded for perversity? There is no perversity pleaded out. Your only question is whether the vendor of the plaintiff, while granting the path on the northern side of the land sold by Exhibit 1, has the right to include the land already sold to the plaintiff in order
already
to
said,
form a 15-feet lot. So, you have not mentioned anywhere in the sale deed that which proportion is being encroached.
so let's say the page number 19.
Yes.
District
Yeah.
Kachar,
This is only one katha 12 lesser.
second,
12 chetang. Is this the land? What is your boundary?
my boundary is east, Uttarayan complex, then. Tikatay, Chata,
North is Uttarayan complex, east.
west Langai,
East is Uttarayan complex. It doesn't have a path, 12-feet path. West is Lonkai Lake. This is
it
west.
is only western side.
North, land of Sasanka Pal Tanti. North. North is this way. South, land of Sri Palak Dev.
Collective plenty.
So, as per your map, how can your map also his land is there if we catch the 15 feet?
But on the bottom of that mirror, the my land is this. And
No, you are saying here, you did not go for commission, nothing has been done. Let's see your boundary. Where is your sale deed? Where is it? Here it says, see. 6 ফুট, 12 ফুট, পশ্চিম, west. What is this? I don't understand. Yeah, not true, so we dismiss. I'm coming back. Can't help it.
At the time of the proposition, admitted that 15 feet wide path is not passing through the southern side, the residence
The paragraph number
48,
48.
page 39.
48, 50, page 48.
Page 39.
Of whose judgment?
Try
Okay, paragraph number 48. Okay.
48.
PW1 at the time of cross-examination admitted that the 15-feet path is not passing through the southern side of the residence of the defendant. Defendant number 1 also specifically stated to in his cross-examination that he constructed the boundary wall on all 4 sides in the Iman. It was also came out while in cross-examining the boundary wall has not been broken but only tilted.
Well, the it is the finding of the trial court. And he stated
Let us see the plaint. Where is it?
plain,
The plaint.
plain is at page 8. Page 9, paragraph number 4 is important. Dependent land is contiguous to the land of the plaintiff's. He has not stated that there is a road of it.
That finding is not correct, my lord. In evidence contrary.
No, the problem arises because the learned first appellate court did not
Yes.
decide that.
But,
The decision of the first appellate court is wrong on that.
but with respect to cross-examination, my cross-examination as well as vis-a-vis cross-examination of the defendant. May I read 2 paragraphs of the cross-examination of the defendant, my lord? The land is mentioned in the southern boundary of my land has been purchased by the plaintiff belonging to my vendors. I know the contents of Exhibit B. Then I have filed WS along with counterclaim in the suit. I have not raised any objection as against Exhibit B in my WS and counterclaim on the ground that I have not also claimed prayed for cancellation of Exhibit B. In Exhibit B, it has been mentioned by the vendor that the said vendor had given right of use of enjoyment of movement to bring water, electricity, so-and-so connection by the said path having wide 15 feet in wide. The vendor of the plaintiff has half share each. House of the so-and-so. Then again, another paragraph in Exhibit J, when he has taken permission,
No, is it your case in your plane? That the entire 15 feet road have been encroached by him?
it is yes.
Waste.
Recovery of schedule 2 land. Schedule 2 land,
So that means
schedule 2 land
there is no 15 feet path road now.
now, no.
So he has encroached his land.
Not only this 7.5 feet, by 7.5 feet also.
So that means what is your what is his northern boundary then?
Not this northern boundary is in evidence is said that northern boundary is my land,
Southern boundary is your land.
southern boundary is there.
What is his eastern boundary?
Eastern boundary is
Road.
in, yes. In my title deed, exhibit A, it is mentioned that the 12 feet wide path in the
Did you
western
amend the suit?
side of my plan.
Did you amend your plane? No, na? Is this the plaint? Plaint is here, na? Page 8.
Page 8.
How many schedules are there? Only one. Where there are two schedules? Okay, path. Path running from by north to the schedule 1 land. Having 15 feet width, north and south, and 80 feet in length. What is your basis to say 80 feet on length?
80 feet. Well, Lord, the land which he has purchased 3 katha 8 katha. My sale deed mentioned 4 katha
8 feet.
8 katha, out of which I will use only 3 katha 8 katha, and remaining as a park.
And you are saying about 80 feet in length,
Yes.
the 15 feet.
If we measure it 80 feet into 15 feet, then it
So
will come
from east is the lane of Uttarayan complex.
Yeah.
That is the lane, east. And west is Longlai Khal. So
Longlai
it-
Khal.
from there, it comes to this place.
this part.
Now, is it mentioned in your sale deed, this schedule?
Yes. 15 feet path has been mentioned.
And from where to where?
My sale deed. তফসিল পূর্বে রত্না চক্রবর্তী ও রাস্তা রোড ইজ দেয়ার
Wait. Today, east is Ratna Chakraborty and road. Okay, that is the road will be lane of Uttarayan complex.
yes, that is subsequently Uttarayan complex came out.
Okay. Then
পশ্চিমে নালা ও
west is drain and land of the same dag.
নালা, that means drain,
Ah.
that is Longai drain,
And
and land of same dark.
so that means it will include your land. Same dag means this is the entire nala.
Nala, and thereafter also there are land of this person from whom I have purchased, they have also purchased. Vendor of the plaintiff and defendant.
Because everybody has on the south that land, then how does the west in the schedule 2 land is not of the same dag?
Schedule 2 land, yes,
Why?
because
It goes to the land. You see, your west is drain and land of the same dag. So, first of all, did you prove that what is this? What is there in the west?
west of
Your land.
my land.
Because the main contention is as to whether the 15 feet is 80 feet long. How did you prove that? Because I think his land, your land, and his land, Dag is same.
Yes, because he purchased in the month of May, I have purchased in the month of
So
July.
the tag will be same.
That will be the same.
So if the tag would be same, then some part will be on his land also on the west.
Well, one thing I point out in his cross-examination, when he obtained the permission for building, my lord, that cross-examination part may I read, my lord? In exhibit J, my land area has been mentioned 211.99 square meter.
Now you kindly come to north of that land in the sale
Yes,
deed.
after
No,
this,
no, no, no. First come to your sale deed, north.
not this 15 feet road.
Read it.
উত্তরে বর্ণিত proposed 15 feet road.
So it has not happened till then.
Proposed 15 feet.
Proposed, no. Varnita means above mentioned.
বর্ণিত
Varnita means above mentioned, not proposed.
Above mentioned 15 feet rule. If that be so,
it cell deed also in contents of the cell deed also 15 feet road mentioned. That is প্রকাশ থাকা আবশ্যক যে উক্ত জমির উত্তর সীমানা দিয়া আমাদের শক্ত হইতে 7 and 6 ইঞ্চি 7 feet and 6 ইঞ্চি ও আপনার খরিদা সত্ত্ব হইতে 7 feet and 6 ইঞ্চি মোট 15 ফুট প্রস্থ রাস্তা উক্ত রাস্তা দিয়া চলাচল ও রাস্তার পার্শ্ব দিয়া জলের লাইন টেলিফোন লাইন ইলেকট্রিক আদি দিয়া ব্যবস্থা থাকে কন্টেন্ট দিদি not only schedule.
and what is east of his land?
East of his land, he said that my land. In the cell deed.
No, no, it can't be
Road.
his land.
Sorry, road. Rotna Chakraborty and road.
His land also. Show me that. I'll read that.
Exhibit A to A, exhibit A to side. দ্বিতীয় রিজরিপার 138 নং পাট্টার 385 দাগে মোট 600 শতাংশ জমি টোটাল 3 কাঠা 8 শতাংশ জমি বটে উক্ত জমির 600 পূর্বে বর্ণিত রাস্তার মধ্যে আমাদের সত্ত্ব হইতে 6 ফুট ও আপনার খরিদা সত্ত্ব হইতে 6 ফুট মোট 12 ফুট রাস্তা দেন পশ্চিমে লঙ্গাই খাল উত্তরে
But he does not put any land on the same dag. Then
দেন উত্তরে তদন্তে 8 তারিখের আগের কবলা খরিদা জমি
so
and
to the east of his land is the 12 feet road.
east পূর্বে পূব
Huh?
পূব east
6 feet from him and 6 point of his. So it's a 12 feet road.
Good.
Now, if that 12 feet road is there, and which does not go to the Uttarayan lane, because your touches on the Uttarayan lane, and Ratna Chakraborty, and his east does not go towards Ratna Chakraborty.
রত্না চক্র
Does it
পূর্বে
go?
বর্ণিত রাস্তা ও আমাদের সত্য হইতে 6 ফুট, আপনার ফরিদা সত্য হইতে 6 ফুট, 12 ফুট প্রস্থ রাস্তা। No mention of রত্না চক্র।
So therefore, this 12 feet road, if your land is diagonally on the south, where is the 12 feet road in your ceiling? Somewhere the ceiling, the 12 feet road has to be there.
This road, which has been mentioned 15 feet, this is only access road to approach my land. From
You see, his case is, he admits some portion of 15 feet road is there. He does not deny them. But he says that you want this 15 feet road,
from
right
this land.
which passes through him to that nala.
That part cross examination is there, my lord. That is why I want to read that part. Exhibit J, my
No,
land
no,
is
but whatever may be, when you are putting schedule 2,
scheduled.
where is your basis to put schedule 2 that it is a 15 feet road having 80 feet length? And it starts from the Uttarayan lane to the Nala. Where do you find that? In your ceiling. That is the question. It should have been, that should be the answer of the learned first appellate court.
Lord, one thing, again, my schedule, I clarify my lord. পূর্বে রত্না চক্রবর্তী ও রোড, পশ্চিমে নালা ও নালা ও that means Longai Nala and then other land. উত্তরে বর্ণিত 15 feet road.
So the reason
my-
why they have put
And,
on the
and
west,
in the
on the west, Nala and Sendag is because here that will be the same dag, na?
my lord, in the cross examination, he said, I do not have any claim in the land situated in the southern side of my land.
Huh?
His southern side. My northern side, his southern side. So I do not have any claim in the land situated in the southern side of my land. Southern side, it is mentioned that southern side.
Obviously, he doesn't have any claim on the southern side
Yes.
because your land is on the southern side.
My-
No quarrel with that.
It-
But the question is, you see, he's not saying that there is no 15 feet road from the Uttarayan lane to his land. But what is not there? You cannot say that the road is 80 feet from Uttarayan lane. That is the issue, isn't it, Mr. Sharma?
Yes.
And another aspect, my lord. His land is access to his purchased land. That is come out from the evidence.
Huh?
His land, he purchased 3 kata, 8 kata. His land is access, he is possessing excess land. That is the evidence.
What does he say?
That is, I do not, in exhibit J, my land area has been mentioned 211.95 square meter. 3 kata, 8 kata is equal to 2520 square feet, equals to 2753. That means he purchased 2520 square feet land and he is possessing 2753 square feet land. Whether this land area mentioned in exhibit J
is in excess than the quantum of land purchased by me. I cannot say the length and breadth of my building situated on my land. The setback in this respect of my building is mentioned exhibit H. Floor area of my building is so and so. It is not a fact that I have shown excess land while obtaining construction permission, exhibit G. And in exhibit J,
No, there is no quarrel that he may be in excess. But is he in excess of the entire land? You see, you are asking about Schedule 2 land. Schedule 2 land is 15 feet by 80 feet, which corresponds to around how much?
one kata something. It is in India.
1200 square feet. So it is around 1200 square feet. He says that he is in excess of 200.
No, 200, not 200.
Yes, 2700 and 2500.
Yes.
Then, so it's around 200. But where is the 1000? Get the point. So where is the clarity to the effect that it is from 15 feet to 80 feet? Without an Amin commission, how is it possible to do this?
It is not possible.
Not possible.
Not possible.
In fact, the first appellate court ought to have decided that aspect. And it should have come. That is why I asked you the first question out here, whether the first appellate court categorically came to an opinion. The judgment is somewhere this way or that way, which has
yeah.
no
I
relevance.
also called, instructed my client that whether there was any Amin commission. Said no.
So the
Without
question is, because
if
see,
this-
he's not,
If his land 3 kata 8 shatak is measured and my land is measured, automatically it will comes out what is whether there is an excess land or not.
no, he say, no, the most important part of his sale deed is, to the north of his sale deed is the 12-feet road.
East.
His sale deed says to the north, into the east, is the 12-feet road of which 6 feet is his and 6 feet is of the owner.
Owner. That is yes.
Why it is from the owner? Now you see from that 6 feet, from there, that part, the entire 15 feet, and comes the 12 feet. Okay? So it is more like a diagonal type of land.
Diagonal type.
Schedule B, although it is straight, but it appears to be a diagonal portion of land, taking into account that from north to south, it runs 12 feet. Then east and west, it runs 15 feet. So it seems to be a diagonal portion of land. So this very aspect of the matter has not been taken. I can't decide this. Try to first appellate court.
First appellate court for Amin commission.
Amin commission he may take, because
Amin
you have a big problem out there that you have mentioned about 80 feet. Now, is your land 80 feet?
Yes, 80 feet.
What is your land, total land you have purchased?
80 feet into that is yeah,
What is your land from east to north to south? What is the length of your land? That is obviously not there. That is not there.
Actually, this is a case of without Amin commission, it cannot be, my lord. And if it is Amin commission is appointed, everything will be clear.
This should have been done.
This should have been done by the learned, trial court only.
No,
But
you should have applied. But he's, though I am remanding it, but his counterclaims is dismissed. Because this appeal is only against the judgment insofar as your plaintiff. Which one?
Yes.
Not the other one.
But we have not two appeals, but we.
No, 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 you have to choose. Then you have to pay the extra court fee.
Two court fees, and
Huh?
two court fee for the plate as well as the complaint.
You have paid here. How much?
that is there, my lord, the area mentioned of the land, 80 feet into 100 meters, 80 into 100.
Where?
In my evidence.
Your land.
Cross-examination,
Your land.
yeah, my land.
So it is by north and south,
The,
it is 100
100.
and this is 80.
80.
So therefore, how you are now trying to say that this 15 feet is still there, which may be wrong because it has to have either same dark means that 12 feet is there. Not his land, but that 12 feet road is there where he has 6 feet road.
So 12 feet, in my part, 12 feet is not there.
No,
Because
no.
in the eastern part, it is diagonal shape, L shape.
No, your land is okay. So your, you see, on your side is 11 feet, 15 feet road towards the north is 15 feet road. There's no quarrel. But there is the entire thing, if it is a 15 feet road, your sale deed will go. Because his land is there, there is no quarrel because he's from his south is your land, which have been sold.
South is
South is your land. So it cannot be that to your north, it is only 15 feet. Get the point? So that would have a problem.
actually 7.5 feet from my part, and the vendor has given 7.5.
Understood 7.5 feet he has given, but he sale deed says that his south is his land, south is your land. Not your land, but his land. And that is the
Vendor-
portion of the land which has
vendor-
been sold.
That is the,
Sold. So he could not have given a 15 feet from there for the entire thing. Otherwise, it will inflict upon his first sale.
first sale will not increase.
Yes, just let see. His sale deed categorically says, which is prior in the time, that to his south, it is the land of the vendor.
Vendor.
Okay. Now the vendor does not put on the north his land.
Yes.
He puts the 15 feet
15
road,
feet.
which
So
means
this 15-foot road should not touch the land of the defendant.
for his land, therefore, if his land is your, the same land is being sold to you, and his sale deed is the first, whereby on the south is your land, it couldn't have been the entire 15 feet.
That is not my saying is that without touching his land, which he has purchased, leaving that land, he has kept 7.5 feet from his part, then
But your sale deed does not say so.
tell it say only 15 feet.
Ah, that is what I'm saying. He said your sale deed should have said 15 feet road
Then
and his
then
land.
his land. That part is not there.
That is the
That
issue.
part is not there.
So now what is being sought to be executed out there is something to that effect. So I think while remanding, giving both sides the evidence, you need to come and clarify that aspect. if both of you can, why don't you see, all said and done, why don't you, this is the issue. Why should I remand it back? Why don't you enter into a compromise to that affair? Come up before this court. Because while remanding it may touch, you never know. The court may say about the field, it is on the 15 feet road, which could not have been the counterclaim, all these things will be. Now he admits to the fact that yes, there is a 15 feet road, but the 15 feet road which comes from there, from here it will be this much. You see his diagram. Give it to him.
My lord, one thing, in the cross-examination also, this part has come that whether he purchased land, 3 katha, 8 katha, is there or not. He
No,
said
no, you
it is
see-
excess land.
You see what can be done. You can here also agree, both of you agree for an Amin commission. Amin commission you can agree, both of you. I can order the circle officer to make an Amin commission and
Yes,
submit
that
a report
That I have no objection.
to the report. Now, if that is being done, how much each person is being doing? Now, this very diagram shows, which Mr. Sharma has given, is that there is a 15 feet which he duly acknowledges to his east.
One, this part has been left out, this part.
That is what.
That is why, my lord, my prayer that circle officer may be appointed.
No.
I-
This
I am-
part can be left out means I tell you why. That is what I have been telling you. This is his land, which is Pran Gopal Sinha. Okay,
Yes,
so Pran Gopal Sinha's land to the south in his same deed is the land of your vendor. Okay, your land to the east is the 12 feet road, 6 feet, 6 feet.
my,
Yes, yes, to your east it is a 12 feet road.
my,
Yes, see,
it is in there is.
Miss, you look into your sale deed. There is this Ratneshwar, whatever may be, along with that Uttarayan port. See your sale deed.
Ratna Chakrabarti.
His land, not yours. See your sale deed.
Ratna
see.
Chakrabarti wo
Okay.
rasta.
Huh?
Ratna Chak-
Ratna Chakrabarti wo rasta.
Ratna Chakrabarti,
That is your land.
Ratna Chakrabarti, oh Rasta.
No. That is his land. No, your land. No, I'm not on his land.
His
His.
land.
You see this.
Yes, there is.
So therefore, his land is this 12 feet.
His 12 feet road.
12 feet road, which is there in the east. If 12 feet road is there, yours is Uttarayan and so and so. Uttarayan and Ratna Chakrabarti to the east.
One thing, my lord, this diagram, this 12 feet road is not touched my land. That is the problem.
No, it is not the, it is not, it won't
Because
because, no, it won't.
This diagram which has been shown, my lord, it is slightly different.
No, understood,
That is
understood
slightly
everything.
different.
But it's not is, his east is a 12 feet road.
Yeah.
Okay? If it is his east is 12 feet road and his land, southern part touches your land
Southern part touches my land.
and there is no lane.
No land.
How is it possible?
That is the problem, my lord. That is the, I cannot enter into my house only 3 feet passes through the land of, southern part of his land. L shape.
So, no, what he want, you see, kindly see this map,
Yes.
which Mr. Sharma has given. He would have no objection in this area of 15 feet.
Lord, this 15 feet, which has been shown, not from his land.
No, I understand. These 15 feet will touch his land.
end this land. From end of this land.
Understood. So these 15 feet will come directly to his land.
My contention is that it is up to Longai.
So where is it in your sale deed that it is still long line? I'm asking you that specific question. Where did you prove that it is 15 feet by 80 feet?
উত্তরে বর্ণিত 15 ফুট রাস্তা, দেন পশ্চিমে নালা and পূবে রত্না চক্রবর্তী road. Poob and that means east and west. The north 15 feet road, south separate. So this 15 feet road touches from east to west.
How do you say so? That is why that is your problem with your sale deed. Because if his land is on the south, from his land, that is there any land between his land and the land of the vendor on the south?
South, there is no mention. Because
So
road,
there is no mention of any other land. So this very land has been sold to you.
is still it.
So therefore, if both of you agree to the effect that these 15 feet which he gives in the map, till his land, till the 12 feet road, because some portion somewhere the 12 feet road ends, becomes smaller because it conjoins with the 15 feet road. Okay, so till that, so his land, this can be very well demarcated and found out how much land it is, 3 katha, 8 lechas. This is his land, maybe extra something or other. And then your land is 4 katha, 8 lecha, and then to submit a report before the court.
Yes.
And on the basis of that, if it can be decreed.
Yes. That I have no. That I have no objection. It will be easier for me then.
One of you filed that application. Order 41 to 27. Then I can direct that because this is required for the purpose of the judgment. And then seek for the report.
I will file it.
Anybody who wants to file it, let him file it. He file it because he's the appellant, nah? Because why do you acknowledge your shortcomings by filing that?
Let my other side.
Mr. Sharma, you file it. You file it. Once we do this, there should be, I don't want to go much into this. If he can have this 15 feet road from there to the 12 feet road or till your land after this demarcation, which is only 3 katha 8 lechas and his land is 4 katha 8 lechas, and this can be very well done. Because why I'm thinking is, if I send it back, there will be trouble for both of you, apart from the delay which is facing. So let this be done. And both of you jointly file this application later on after the report comes. Let's see what we get the report. Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. G. Bharadwaj and Mr. S.K. Ghosh, the learned counsel appearing for the appellant, and Mr. S.K. Ghosh, the learned counsel appearing on behalf of the appellant. Respondent. This court heard the matter at length. And from a perusal of the same, and while hearing the matter and taking into account the evidence on record, it is seen that the dispute involved in the instant proceeding is primarily in dispute pertaining to the boundaries of the land. It is well settled that when there is a dispute as regards the boundary, the learned court, trial court, or the first appellate court, who are the courts of dealing with facts, ought to have issued an commission to ascertain the exact boundaries. However, both the courts failed to do so. This court further takes note of the Mr. A.C. Sharma, the learned senior counsel, submits that the instant suit has been pending since 2009. And as such, as if additional evidence is being taken by this court only on the question of by directing appointment of an commission, it would be in the interest of it would be helpful for the purpose of delivering for adjudging the instant appeal. Mr. S.K. Ghosh also submits that he has no objection if such application is filed. This court further takes note of the substantial question of law so formulated by the court net bench, which also touches on the question as to whether any part of the land of the appellant, who was the defendant in the suit, was sold by the vendor of the appellant subsequently to the defendant, to the plaintiff, in violation by plaintiff, and as to whether Section 48 of the Transfer of Property Act 1882 would be applicable. Considering the above, this matter again on 25th March, we filed the application. 25th of March 2025. The appellant shall take appropriate steps for filing such application. Once you file the application, we direct that, and I think then we can close this. Unnecessary sending it, I can send it, it will be easier. But the only worry out there is, you see, there is a problem with the sale deed of his, and it may have some repercussions to the effect. So I don't want to disturb that. If we can see your land as per Trikatha 8 lecture, and what is the breadth of this and not, and then if the land, and from there any 15 feet road is there as per your diagram, then it will be easier for him also. The interim or the posterior shall continue.
Item 16.
Yes, what is this? Why is such an old matter here?
Initially, it was placed at some point of time.
Huh?
The benches kept changing. Initially, the registry placed it before the single bench, then it went to the division bench. Again, it came back to the single bench. Some time was consumed. I took a date or two in between. Otherwise,
what are you challenging?
The petitioner, he was working as a copyist on temporary basis.
Why there is no affidavit?
There is an affidavit.
Affidavit there.
Yes,
Okay, what are you challenging? You are declaring should be issued that the impugn action on the part of the respondent authorities in not selecting the name of the petitioner in the list of candidates selected for viva voce and computer for the post of copyist in the office of the respondent number 6 is not giving due weightage. Yes, what are you challenging?
what had happened is he was working on temporary capacity as a copyist in the MSc Nalbari. An advertisement was issued for regular appointment. He approached this honorable court. Now, this honorable court, going through the advertisement, said that he will be given due weightage of his experience at the time of the selection.
On administrative side or judicial side?
The advertisement said so, therefore, the judicial order that came to be given. That will be given. If Lordship
But
has
did the advertisement say so?
Yes.
Advertisement also says so.
Yes.
Okay, then.
At page 12 is the advertisement. No, that is page 39, I'm sorry, annexure 2.
Well,
39. Candidates having experience in judicial work or working in judicial establishment with requisite qualification and etc. shall be given due weightage. Okay, then.
So thereafter the orders of this honorable court at page 43 on 44 is the relevant section.
And then.
Then, my lord, I participated in the process.
Hmm.
A written test was held and I was not called to the interview. I made an application.
Well, what test was held?
Written test.
Okay.
I was not called for the interview thereafter for the computer test, and therefore I filed an application whereupon I was told that the due weightage would be given. The weightage would be given only if I qualified the written test. I approached this honorable court by this petition, and in the affidavit of opposition now it has come out that after the written test was conducted, the results were known as to who scored what. It is at that point of time that the board decided that we will have 50% as the cutoff for polling for. But I have only 2 rounds to stand up for
50% they will go for cutoff.
cutoff.
After the results.
After the results were known. We were not told the results, but after they knew the marks. After the marks were given to everybody, it was at that point of time.
Not before that.
Not before. So
why cutoff?
There were several candidates, they wanted to bring down the competition.
Was it mentioned in the advertisement there?
No, that was not there in the advertisement, and therefore either I had to be called for the interview and the computer test and given a due weightage.
Why the matter has been pending such long? What do I do after 10 years? Tell me. After 10 years, would it be possible on the part to interfere? You may have a good case, but what to do?
The only respect perhaps I would have is if there was an illegality committed. If there was an illegality committed.
Illegality committed, whatever may be, but should this court interfere now? 15
The
years.
Gaurav Pradhan's matter is possible.
Huh?
Have a consideration of the Gaurav Pradhan matter in the Supreme Court where they said that if there's an illegality, not disturbing the others, and if he makes the
Others I can. But the fact that this is how many posts were there?
that point of time, one was advertised.
So if that is one post, the selection was held. That post has been filled up. That has been done.
That is what Gaurav Pradhan says, my lord, that if he had made it on merit, if they come up on merit, then perhaps a supernumerary post will also suffice for this person. If there is an illegality as such.
Thereafter, what are you doing for the last 10 years?
He tells me that he is doing odd jobs. Odd jobs, my lord, it's nothing.
How do it is very difficult? How do you unsettle things now? Either the court should have stayed it then or disposed.
There was initially.
What do you say, Mr. Nayak?
We came before the appointment.
You are not a party to the proceedings. How? Okay, so you'll be the fairer person. Tell me. Yes, in this case. On 2018.
Appointment is subject to.
When a written test was declared on demand, the petitioner's name did not figure in the round. Accordingly, he challenged the but it appeared that the case records that the petitioner could secure only 43%, whereas the cutoff for the written test was 50, and that is how the experience became. Anyway, I already let you considering the petitioner has failed to qualify in the authority of the public result of the law say and make appointment, but appointment is made to. But
when you are
preference. not
That
preference.
I understand, that I will look into it, but the question is, Mr. Naik, how do I disturb now? Even assuming Mr. Majumdar's contention is right, that you have come up, you have changed the games of the, what do you call
So the
the
of the game.
rules of the game subsequently. How can I do anything now? For 10 years.
The appointments came in
2011, no, appointment
Appointment
happened
came
in
in 18.
2018.
Father, the owner.
And then also 7
7
years
years.
have gone, huh?
Was appointed. He didn't vie for it. He didn't vie for it any further. It was in 18 when court gave a permission to only at that point of time. He was appointed. He didn't want the appointment. He did not pursue that I should be
No,
appointed. or-
understood, but he got his appointment.
Yes, 7 years.
Now, to how do I unsettle him at such a long time? Hmm?
You try to press for a-
And I would have understood, if it is a promotion, you can do something. But this is only one post. Means I have to remove him, and I can't give you an appointment.
No, I
can't
would only
give you
face
the
the interview.
appointment.
I would face the computer test and the interview. If I qualify in them and with us,
No,
he is correct.
Now, how these interview will be as per the subjective satisfaction of those persons concerned. Now, that person, the same interviewee board is no longer there.
By the posts. Held by the persons who have.
Huh?
We go by the post. Position is difficult, I understand matter, but this man has suffered.
Suffered
Suffered
maybe
in
because of
in
the
a manner
delay,
which he should not have.
because of delay, and the matter has been rolling around for such unnecessary time.
There was a time, my lord, when the matter was placed before the division bench saying that it was a matter which was to be done by the division bench, then it was again sent back to the civil bench. But the pleadings were completed as back as in 2018, that is what this. I came in at a later point of time. Times left
So
out.
your submission is that they fix this weightage of 50% subsequent.
The benchmark of 50%, that is on their affidavit, on their record. By their affidavit, I have come to know. It was never my case in the original pleadings. I never knew that. When they placed the board's resolution before this honorable court in an affidavit, it is then I find out that yes, they did it after
For calling for interview.
to call for interview.
Interview, how much marks?
Interview, they did not declare.
Let us
Viva was 30.
see one
Viva was
thing.
30. Those
The
people have their
advertisement-
resolution. It was perhaps
Advertisement is at page 39, na?
39, madam.
Applicants were already so and so, the applicant for the post of income officer will have to appear in the interview with respect to There's nothing else. How the manner it will be done, it is not mentioned.
That they come up in their affidavit in opposition. Lordship says,
Paragraph
page
6.
6.
Who will respond number 6? Respond number 6 is who?
Deciding officer, member MACT non-guardian.
Whether the publication of the said advertisement, a meeting was held on demand, wherein the resolution regarding detailed procedure to be followed from the petition to the post of so and so was done. 100 marks, general knowledge, officials language, 50, remarkable systems. Where is the resolution? Resolution was taken on 18/5/2020 13. When was the interview? Written test held?
13-7.
Now let us see what the and
Lordship has-
advertisement was passed so and so, so accordingly so and so. You say the was specialized to the provision and acceptance. This is post of copyist.
Copies.
This is on 14/5.
2015. 18, 14. Resolution number 2 will be important for us. At page 9 of the.
When was the examination held?
13/7, 2011.
It's come to a notice that all non-advertisement was free. 13/7/2011.
Sorry,
No.
13 is not 11. I'm sorry, madam.
13. 13/7/2013.
30. 11 and 13.
Then what happened? They sought for a direction.
Then the
Clarification.
direction came, madam. The direction also look fine in my petition at page 45. An extra 15.
In writing reference, the reference to subject letter and above private and following the dead regards to selection. Okay.
2017, 17, 17, 7, 15.
So you filed this petition
Hello?
pursuant to the 77.
Yes. August 2015. Before the Viva was. There was an interim order on the first day that the Viva was may continue. So things continued. An order of 12/8/2015 allowing the Viva to go. Withholding the final results.
If you have known this 50% or 40%, what would you have done? Tell me. You have studied more better. Tell me, there has to be some good reason.
Attempted to perform better.
Huh?
Attempted to perform better.
No, prejudice. I think we need to do this. Sometimes you can't help somebody. This matter should have been taken in 2015 with more earnest. Can't help it.
Still,
Huh?
no matter the Gaurav Pradhan's matter where the illegality, if it is there, it stands a chance for she to make a consideration on that. If there was an illegality, if it goes on to proceed to the interview and the typing test or the test, they'll have to go to the interview at least. He may score it, he may not score it. But this ground that I was illegally kept out of it. Man fails on his merits is another issue, and man fails to get justice after.
A man
That
fails to on merit, you fail in merit also.
In the interview, if the person fails. perhaps
Interview
he
is
put the value-
another thing. They have, that is what I was dealing with one matter about the minimum qualifying marks,
Yes.
which is now your High Court is taking up. So they are having a benchmark of 60%,
Yes.
70%, 80%. In fact, giving the flavor of more of a merit cum seniority.
What I was trying to say is, madam, he may or may not qualify the interview. But today, if the delay, my lord, where he filed it on time, he did whatever he
But
could on
what,
time.
tell me, what can I do?
Well, if lordship finds an illegality here, direct the respondents to hold an interview, an honest interview. He makes the mark with the weightage, perhaps Gaurav Pradhan could come. He fails to make the mark in an honest attempt. He loses it all.
Does the illegality goes to that root of the matter?
It would go because, my lord, when I had approached this court already, seeking for regulation and a weightage was due to be given to me. The
The weightage was already there. The court only passed an order to
Yes.
give you the
So-
weightage. So it was nothing more than a reiteration of what was there.
what was
Now the reiteration, the question is weightage can only be given after you have the minimum qualifying marks. Taking into account, they have put this minimum qualifying
When
mark.
qualifying
that-
marks?
This is called that, what is that term, Mr.
Benchmark
Das,
and
you always put?
We have to. And see.
No, that word, what is that word? It is some efficiency? What is that efficiency word? Huh? Efficiency.
Efficiency bar should have been placed before they knew where I stood. Had it been done before they knew my results,
No, these efficiency bars, so they are saying that, okay, not some good administration efficiency or some, what is the term actually? In the morning, somebody was telling me. Some efficiency. So that was the minimum thing. You did not do it. So
but that had to be decided prior
if
to,
you don't have that enough, so where's the question of going to interview?
that had to be decided, what could be the minimum had to be decided at a time when they put on the question paper, so when they start the interview.
Yes,
Not doing it at
they
that point
should
of
have
time
done it,
is-
but this is not a
Exactly.
case where this court should now exercise it.
Had there been a delay on his part, had there been anything on his part, perhaps I could have.
Understand, this court should have done it something at
No,
that point of time,
it
if
is not-
something was done.
It is the circumstances which led
But
to
the
this
fact
position.
that had what to do? We
With the
can't
2
help it.
years of COVID in between,
Huh?
with the 2 years of COVID in between, everything going everywhere. It was not his fault that that the
I know
matter
it
came
was
to
not
delay.
his fault. But then also, fault or no fault. Now to disturb a position, there is no illegality on the part of the other side. I would have understood if there is an illegality on the part of. Yes, there is, seems to be some violation of Article 16, but nothing so gross. I think this can't be put as CAV. If I put it as CAV, the judgment will run more longer. Mr. R. Mojumdar, the learned counsel, appearing on behalf of the petitioner, Ms. S. Sharma, appears on behalf of the respondents, numbers 1, no, not 1, 1 also, na? 1, 2, 4, 5, 6. Mr. P. Nayak appears for the respondent number 3. The instant petition has been filed challenging the action of the respondent authorities in not selecting the petitioner. As well as seeking mandamus that the petitioner should be selected in terms with the judgment and order dated 23/9/2013 passed by this court. In addition to that, the petitioner have also assailed the communication dated 17/7/2015, as well as the list of candidates dated 29/7/2015. So, the brief facts leading to the filing of the instant petition is that on 13/12/2011, the respondent number 6 had issued a advertisement inviting applications for various numbers of vacancies. The vacancy in the instant case for the purpose, the vacancy which is relevant for the purpose for the present case is the vacancy of one post. Is the post of the copyist, which is a single post. It has been mentioned in the said advertisement that candidates having experience in judicial work or working in the judicial establishment in Assam with requisite qualification shall be given due weightage. Irrespective of, although the said advertisement was issued, the petitioner filed a writ petition before this court challenging the said advertisement and seeking regularization. This court, by an order dated 23/9/2013 in WPC number 1537/2012 did not issue any direction for regularization of the petitioner, but rather taking into account that the petitioner had applied in pursuance to the advertisement, have observed that the respondent number 6 shall give due weightage to the experience of the petitioner while considering his case in the ongoing selection proceedings. Subsequent thereto, it is seen that on 13/7/2013, a written test was held for the post amongst the various candidates for the post of the copyist. It is seen from the records that and more particularly from the affidavit so filed by the respondent number 6 that on 14/5/2015, the selection committee had resolved that a written test which was conducted had passed the resolution. In the same resolution, it was mentioned that a written test was conducted and the cutoff mark was decided at 50% for the copyist. Accordingly, 7 number of candidates were qualified in the written test and they were selected for the viva voce. The petitioner herein, who in view of the order passed in WPC number 1537 of 2012, the selection committee thought it proper that before rejecting the case of the petitioner as he failed to get he could clear the written test, they would seek an opinion from the Guwahati High Court in the administrative side. On seeking such opinion, the Guwahati High Court in the administrative side had opined, as was communicated by the communication dated 17/7/2015, that as the petitioner had failed to secure the minimum cutoff marks for the written examination and for the written test, the due weightage cannot be given as he failed to pass the basic efficiency test. It is under such circumstances, the petitioner being aggrieved, it is further seen that subsequent thereto, a list was prepared of the seven number of candidates. 7 number of candidates, no?
7.
Dated 28/7/2015. And thereupon, a select list was prepared on.
That was a reply to the RTM. And my number is given at the bottom.
Now, what are you challenging? Another document? You're challenging 2 documents, no?
17/7/2015 is an internal communication.
And another one, no?
And yes, sir. Next page.
He's challenging another document.
The opinion by the High Court.
No, that is there. And another one?
Not-
Next is dated 29/7.
Not calling me for the interviews on the channel.
No, you have challenged another document now. What is that?
29/7/2015.
29/7.
That is what is that? Yeah, and yeah, that is what.
Page 46.
And as well as the notice and subsequent thereto, those persons who have cleared the written test were notified by the notice dated 29/7/2015, which is the subject matter, which was also put to challenge. It is seen that the pursuant to the issuance of that initially there was an order of stay of the selection process. However, the said order was vacated by an order dated 18/8/2018. You said about that order?
18. 2018.
18. 8/1/2018. 8/1/2018. But the said was vacated by the 8/1/2018. Good stuff. The respondents have also filed their affidavit, and in the said affidavit, they have their categorical stand taken is that the petitioner failed to secure the minimum 50% of the marks in the written test, and as such, he could not be considered or given due weightage in spite of the order being passed by this court. It has also been mentioned in the said affidavit that they have duly taken note of. They have also sought for confirmation from the Guwahati High Court in the administrative side, and in pursuance thereto, the communication dated 17/7/2017 was issued. 17, now 15.
15/7/2000.
15. I've heard the learned counsels appearing on behalf of the parties and peruse the materials on record. At the outset, the learned counsel appearing on behalf of the Guwahati High Court, respondent authority submitted that the instant proceedings cannot be, the instant petition cannot be proceeded with, taking into account that pursuant to the vacation of the order on 8/1/2018, there has been new incumbent appointed, and such incumbent is not a party to the proceedings. The learned counsel further submits that the instant proceedings is bad on account of a challenge to the notice dated 29/7/2015 without arraying those persons as parties to the instant proceedings. Arraying the selected persons who have qualified in the written test. This court have also heard the learned counsel appearing on behalf of the petitioner in that regard. The learned counsels for the petitioner had submitted that in the order dated 8/1/2018, there is a mention that any appointment shall be so made shall be subject to the outcome of the writ petition. This court, however, finds it relevant to take note of that in pursuance to the selection proceedings, due appointment has been made. In spite of that, if there is no challenge to the appointment order of that particular of the person who have been duly appointed, and if any order is being passed in the instant proceedings, it would result in violation to the principles of natural justice. Consequently, this court is of the opinion that this is not a case where this court should exercise its jurisdiction under Article 2 to 6 of the Constitution, for which the petition stands dismissed. This is the only way without going to that space.
There was a 2018 letter which the appointment letter says is subject to outcome of the petition.
Maybe, but he is not a party.
If I may seek your lordship's
Huh?
guidance, 20th and 21st, my lord, I have an urgent personal commitment, my lord. I'll be out of station, my lord. My learned colleagues will make a mention. Deeply obliged.